My lord.
Yes, sir.
Good afternoon, sir.
Good afternoon.
My lord.
Okay, we are on air now. Good morning, my lord, the Honorable Chief Judge of Lagos State, the distinguished and Honorable Attorney General of Lagos State, learned senior advocates of Nigeria in attendance, distinguished colleagues, ladies and gentlemen. This is the Lagos Justice Summit. It's been hosted by the Ministry of Justice, Lagos State, the Commercial and Regulatory and Investment Disputes Best Practices, CRID-LawNet, as well as the Justice Reform Project, JRP. And the purpose of this workshop is to familiarize ladies and gentlemen who are attending with the distant remote hearing practice directions recently enacted into a practice direction by my lord, the Honorable Chief Judge of Lagos State, to be applicable to urgent, time-bound, essential cases that have been filed or that may be filed during the period of the COVID pandemic. My Lord, the Honorable CJ of Lagos State Public Practice Directions on the 4th of May, 2020. And we thought, the Ministry of Justice, CRID-LawNet, and JRP thought that it was important to provide a platform to discuss the way forward during the COVID pandemic and after the COVID pandemic. Thanks to the efforts of the Honorable CJ, we have a set of rules to guide the hearing of urgent, essential, and time-bound cases. However, on the most optimistic prediction, the one that I last saw on international media, the earliest time that a vaccine is likely to be available is anywhere between 12 to 18 months, and that pretty much takes us into the first quarter of 2021. All over the world, courts of different jurisdictions are examining how to reopen for normal business. The remote hearing practice directions are a very good first step. This workshop will be looking at those remote hearing practice directions. We'll also be looking at what opportunities there are to scale up the application of virtual hearing technology to other matters aside from urgent, time-bound, and essential cases. In effect, the normal business of the court. And to discuss this subject today, we have a distinguished group of panelists, and I will introduce each one of them one by one. My Lord, the Honorable Chief Judge of Lagos State, who has joined us, will be presenting very briefly for 10 minutes the Lagos State practice directions on remote hearing of cases during the COVID-19 pandemic. We will then hear from my Lord, the Honorable Justice Hakeem Oshodi of the High Court of Lagos State on what the prospects are for restoring full service in justice delivery, scaling up the use of virtual hearing technology. We will then listen to Mr. Dan Wilmot, who works with the law firm of Stewarts in the United Kingdom and has just concluded, he and his partners have just concluded a case in the commercial court in England that was commenced and concluded exclusively using remote hearing technology. We will hear from Professor Osipitan, Senior Advocate of Nigeria, and Mrs. Funke Agbor, Senior Advocate of Nigeria, on what evidential problems could arise when we try to use virtual hearing technology to conduct actual trials. That's matters in which you have to call witnesses. Then we will hear from Mr. Shasore and Mrs. Miannaya Essien on what possible constitutional issues could arise when using remote hearing technology. Before I call upon this distinguished panel of speakers, the organizations that have provided a platform for this workshop will present just for 3 minutes each through their representatives and their leaders, an introduction to the organizations themselves and their mission. Starting with the Honorable Attorney General of Lagos State, Mr. Onigbanjo, Essien, and then we will hear from Mrs. Toki Mabogunje, the President of the Lagos Chamber of Commerce, which is the mother body of CRID-LawNet. We will hear from the President of CRID-LawNet himself, Mr. Taiwo Oyetibo, Senior Advocate of Nigeria, and we will then hear from Mr. Shasore, who represents Senior Advocate of Nigeria, who represents the Justice Reform Project. So before I hand over to you, Honorable Attorney General, I will quickly adjust my tie. I have been at home for so long, I've almost forgotten how to knot a tie. So please forgive me. So Honorable Attorney General, over to you. Thank you very much, sir.
Thank you very much, Leonard Senior Advocate. It gives me great pleasure to be addressing all our distinguished colleagues this morning. I see that we have on board the Honorable Chief Judge of Lagos State, Mr. Justice Kazeem Alogba. I also recognize the presence of a very distinguished predecessor in office, Mr. Olasupo Shasore, Essien. May I then stand on the protocols as established by Tunde? At the Lagos State Ministry of Justice, we recognize the times that we are in, and we feel that it is incumbent upon us as the vanguards standing standing at the doorway to the administration of justice to ensure that this pandemic does not ground or paralyze the administration of justice. As a result, we entered into consultations and discussions with the Honorable Chief Judge about issuing a practice direction which will address or permit our colleagues to go to work with their safety being paramount. Indeed, there's no doubt that we stand on the verge of history, as history will record us as having, at this stage, virtually done something which hitherto in Nigeria had not been done. The first practice directions in Nigeria, to my knowledge, dealing with remote sittings of court is the one issued by my Lord the CJ on the 4th of May, 2020. There's no doubt in our mind that it is an idea whose time has come, and it's going forward. I believe that it's going to be the perhaps only platform available for us to practice law safely until the vaccine is discovered to treat the COVID-19. So our role in the Ministry of Justice really is to ensure that everything continues to work and that lawyers and all the end users of the justice system do so in a safe atmosphere. I haven't said this much. It is my pleasure to welcome you all and indeed to wish each and every one of us very, very fruitful deliberations this afternoon. Thank you very much.
Thank you very much, Honorable Attorney General. Mrs. Toki Mabogunje, the President of the Lagos Chamber of Commerce, the floor is yours.
Thank you very much, sir. The Chief Judge of Lagos State, Honorable Mr. Justice Kazeem Alogba, the Attorney General of Lagos State, Mr. Moyosore, Onigbanjo, Essien, Mr. Shasore, Essien of the Justice Sectors, Mr. Babatunde Fagundu, Essien, distinguished panelists and speakers, distinguished ladies and gentlemen. On behalf of the Lagos Chamber of Commerce and Industry, LCCI, I join Lagos State, CRID-LawNet, and the Justice Reform Project in welcoming you all to this virtual workshop with the theme, Making Virtual Hearings Work. We're honored by the presence of the eminent personalities from the bench and the bar at this virtual workshop, and we thank you sincerely for honoring this invitation. The Lagos Chamber of Commerce International Arbitration Center, known as LASEAC, is an independent full-service alternative dispute resolution center that's affiliated with the LCCI. LASEAC focuses on the provision of tailored dispute management solutions, assisting businesses not only in their resolutions, but in the management of disputes. LASEAC aims to provide a viable and user-friendly alternative to traditional litigation, offering a full service of ADR solutions, including arbitration, mediation, and conciliation. CRID-LawNet, on the other hand, is a project of the Lagos Chamber of Commerce and Industry, LCCI, and it's an advocacy group whose primary focus is to promote best practice across all functions which impact justice delivery in commercial disputes. LASEAC is quite involved in the rollout of this project, and the mission of CRID-LawNet is to transform the culture of commercial dispute resolutions in a positive way by engaging stakeholders through programs and activities in order to reform laws, develop institutions, and build human capacity that will support the effective dispute resolution. To this end, CRID-LawNet collaborates with state, judicial, and legislative bodies, as well as branches of the NBA on specific activities. At the LCCI, we are quite pleased that LASEAC is in the vanguard of deepening the awareness and knowledge of the value of digital applications to the operations and processes in our judicial service delivery system. The use of technology in our processes and interactions is now the new normal. The COVID-19 pandemic, having caused several disruptions to various spheres of our national lives, is causing us to transform our judicial systems. A positive outcome of this pandemic has been the amazing traction that the use of digital platforms has gained in the last 2 months. Even the most conservative institutions are now embracing the use of digital platforms for their engagements, operations, and processes. And our judiciary is not an exception to adoption of this new normal. I believe there's tremendous value to be gained from this transition. The LCCI will continue to commit and provide all of the necessary support for the advancements of the work of LASEAC and CRID-LawNet. And once again, I thank you all for honoring this invitation. I look forward to an exciting and enriching session. Thank you for attention. Thank you, Chair.
Thank you very much, Madam President. We are 6 minutes behind time. I would hand over the floor to President CRID-LawNet, Mr. Taiwo Oyetibo, Essien. Please, if you can accomplish this in 2 minutes, I'd be very grateful. Thank you very much.
Yeah, thank you, Tunde. I greet my Lord, the Chief Judge, and the Attorney General, and all participants. As we've all been told, this workshop has been put together by CRID-LawNet. CRID-LawNet is a non-governmental advocacy group. We committed to the promotion of best practices in the resolution of commercial disputes. Membership of the body is open to corporate organizations, including lawyers and individuals. CRID-LawNet is committed to a number of projects aimed at advancing best practices in the resolution of commercial disputes. And the flagship of this progress is the Administration of Civil Justice Bill. The bill has been introduced to a number of states of the Federation, but in particular, the state has, however, taken the lead by enacting the bill into law in the year 2019. The Federal Attorney General is also currently taking a look at the bill, and we are hopeful that it will very soon be introduced at the National Assembly. We're also looking forward to Lagos State adopting and enacting the bill into law. So if I may give the notice, very soon we will be knocking on the door of my Lord, the Chief Judge, as well as the Attorney General of Lagos State, to have their input into this bill, with a view to introducing it at the State House of Assembly. Today, we have quite a number of cerebral speakers, and I'm sure at the end of the workshop, we will be glad to go that we have attended this workshop and have learned a lot as to how we can make virtual hearings work. Thank you. As we commence.
Thank you very much, Mr. Oyetibo. And then I will now hand over to Mr. Shasore to introduce the Justice Reform Project. Mr. Shasore, Essien, the floor is yours.
Thank you very much. Good morning, my Lord, the Chief Judge, Learned Senior Advocate of Nigeria, the Honorable Attorney General of Lagos State. Ladies and gentlemen, it's a pleasure for me to represent the Justice Reform Project. My name is Olasupo Shasore. I'm a partner in ALP. JRP is a company limited by guarantee. Therefore, it is a registered not-for-profit. Its main objectives are to promote the advancement of the justice sector. We are specifically dedicated to ensuring that data, information, and other related materials are available to the justice sector, because we believe that that is an important tool for innovation and reform. We think that the state of our justice sector in Nigeria and many parts of it individually require critical looking at this stage, and we offer ourselves to be a vehicle for that improvement. So we want to improve access to justice and ensure that other reforms and other like-minded organizations collaborate with us in doing so. JRP is a coalition of Nigerians from across the legal profession, civil society, academia, and the general public at large, because we believe that we are all stakeholders in the justice sector. And the mission of reform and renewal is something that should be dear to every citizen in Nigeria. And we have several watchdog functions, and we are committed to making sure that our interventions in the sector are both purposeful and engaging. Some of our tools for intervention, I think it's important to mention, involve engagement and dialogue, events such as this, investigation where necessary, online public complaints and the whistleblower platforms, our petitioning method in order to advocate for change. Certain areas that require transparency we think must be exposed. We will engage in public interest litigation where necessary, and training. JRP is particularly delighted, on a final note, to be part of this, because this measure introduced by my Lord, the Honorable Chief Judge, and the innovative Lagos State generally, is one of both innovation and technology. And we think these are veritable tools for reform. So we are delighted to be part of this conversation, and we hope we can make useful contributions to making sure that this is an ultimate success. Thank you.
Thank you very much, Mr. Shasore Essien. So the stage is now set for the plenary session of this virtual workshop, and it will be flagged off by my Lord, the Honorable Chief Judge of Lagos State, Honorable Mr. Justice Kazeem Alogba. My Lord, congratulations on the issuance of the Lagos State Practice Directions on remote hearing of cases during the COVID-19 pandemic. I will now hand over the floor to you, sir, to introduce the directions to the audience and basically give us your perspectives on how you think we can now move forward from the urgent time-bound cases to opening up the business of the courts a little more. I give you the floor, my Lord, sir. My Lord, I think your phone is still on mute. I think you will have to take your phone off mute to be able to, for us to be able to hear you, sir.
Hello? Hello?
Yes, we can hear your voice, my Lord.
Thank you very much.
Alternatively, I'm not sure if the administrator can. Right. My Lord, you're on air now. Thank you very much, sir.
Hello? Thank you very much. Well, I also extend all courses earlier extended just to save time, but I may not begin without mentioning the fact, which I observed, that Taiwo's fundamental right was breached when you cut 1 minute from his own time. But when it came to the time of Shasore, you allowed him to speak fully. I don't think this has to do with height, but it is one of the things we may be dealing with during virtual hearings. So we may note it for now.
Thank you, my Lord, for speaking for me.
Thank you very much. I welcome. Thank you very much. I will not accept any fee for the brief. I thank everybody
Very well.
for this gathering. And it only shows that we are not oblivious of the times we are in now. And as human beings, we are rising up to the occasion, because that is where and how God has made us be better than animals. We are all aware of what led to these practice directions and the need to resort to remote hearings. I do not need to go back on all that. But let me clearly say that the Attorney General, although he's not an economist, was a bit economic with the full facts. Maybe he didn't want to disclose before me that I and him, we had been working on the e-court for Lagos State just shortly before the pandemic started. And both of us would probably have been caught in England if we had traveled as scheduled by this pandemic. But thank God we eventually didn't go for one reason or the other. But we rose up to the occasion in Lagos State in view of the enormity of our caseload and the cry by the public that the justice sector cannot go to sleep, which we realize is also detrimental to security and business, and indeed general life in Lagos State and indeed the entire nation. So we were coming up with bits and pieces of directives on how courts can sit physically. But thereafter, we came up with these remote hearing directions. And the basic reason for that is from the awareness that some matters are time-bound, some matters have constitutional flavor, particularly criminal matters, where the liberty of citizens will be affected unless we find a way of hearing their cases. Basically, applications that will touch on remand, applications for bail, and probably delivery with respect to very serious offenses. And so we started toying with this idea. After some trial runs, we came out with the practice directions. And the aim is not to encapsulate all cases. We made it clear. I want to believe that we all have copies of the practice direction, please. The objectives are clearly stated there: timely and efficient disposal of cases, use of suitable technology and just dissemination of proceedings, and efficient use of available judicial and administrative resources. That last one is very key and probably has limited how far we have gone and how far we could go in the deployment of this method of hearing. We also provided for electronic filing of processes. Realizing how far we have gone, and I want to say that this area had engendered a lot of critique from learned colleagues, electronic filing of processes. We made an alternative that it could also be done at the court registry, knowing the state of technology and infrastructure we have on ground, not only as affecting the judiciary, but also as affecting lawyers and probably other stakeholders too, particularly citizens who may not be opportune to have the kind of technology to enable them to do the filing electronically. But I can announce to you that as of Tuesday, electronic filing has started in Lagos. We have sorted out the little itch we had, and that has to do with the revelation of particulars by people who wanted to file processes. Until I satisfy myself that that's inescapable, particularly I haven't talked to the tax authority about that because complaints were coming from people who wanted to file processes. But I got what's from the tax authorities. There is something that is applicable all over the Federation now. You have to disclose your BVN in order to generate a PID. And then you can thereafter be paying seamlessly. But the long and short of it is that after we have satisfied ourselves on that, Lagos State has now begun electronic filing of processes. But one issue that still remains to be discussed there as to how we can solve it permanently is in situations where documents are very bulky. If you file electronically, yes, we will receive them here. What about the copies that are supposed to be simultaneously filed? Assuming you have a process of about 120 pages and you are meant to submit 12 copies, how do we receive the copies? I can say that as late as about 6:30 p.m. yesterday, I was in a meeting with my team at the High Court here in trying to resolve that. And what we arrived at is that we may have to put in place a mechanism whereby we will have to do some bit of costing for the volume of the papers to be filed. That would be maybe per page or per folio, as they used to call it. And then that will have been, a regime will have been stated out for that. Everybody will know that if you're filing 120 pages, it is $1 per page extra to the original process. So that way, we will now put facilities in place at the High Court Registry here to make mass production of those documents after having been scanned when you are filing in the and so we can upgrade that problem. So that's much on e-filing, and then we'll improve on it as time goes by. Now, we have also said that the registry will receive documents for filing electronically, and that all documents to be filed must be scanned or converted to an appropriate PDF format and forwarded to the registry via the designated email address or WhatsApp. Well, we are stated in these practice directions that notices of hearing of remote hearings will be on the cost list of the courts and as well on the judiciary website. They will also be circulated and posted in appropriate places within the court premises, so that in that way you will have the widest publicity possible of such remote hearings. In the first place, they will be given special place on the court list, boldly marked remote hearings, causes involved will be listed, the costs involved will be listed, and then the particulars of the cases and the time schedule for them will be listed. And also this will be on the judiciary website, so that any party who is interested in any of the proceedings can log in through the website, and then will be allowed in by the administrator of the proceedings to participate, to watch the proceedings. And that's what we did, if you all remember, my dear brothers and sisters, on Monday when my brother Judge Dada J delivered a judgment in a criminal matter. I directed that the face of the judge should be seen, which eventually came up. And then all the parties involved were also seen. And also, so many people who are interested in watching the proceedings were able to participate. I was made to understand that we had almost over 100 people who watched the proceedings. I have directed that in order to give the proceedings such further publicity as much as possible, that will increase the capacity to allow many more people participate by watching proceedings. That we are already doing by putting in the necessary infrastructure to allow that. So that's much for the publicity of the hearings. And that, I may say, will be in a way of addressing the criticism or observation raised by our LawNet colleagues as to whether remote hearings, public hearings. And if I may say straight away, our own take on that is that compared with the normal court situation, only parties and their counsel, and probably where necessary witnesses whenever they were to give evidence, will have been in the courtroom under normal circumstances. Nobody goes to invite anybody to come and watch proceedings. If you are interested, you simply come to the court. And if there is room in the court, you enter, you sit down, you watch proceedings. So likewise too, for virtual hearings, once we provide you with the particulars of what will allow you to be able to log in and watch the proceedings, once the judge sits in open court, and all other parties are logged on, and we can all see ourselves on screen. As for parties, I think the requirement of public hearing has been satisfied. And that again, to further ensure that is why I directed that we scale up. And I don't know of any courtroom, at least in my own state, which can take 300 people watching proceedings at a time. So that this virtual hearing proceeding will even give better and more enhanced opportunities to the public to participate by watching proceedings. So I would think that Section 36 of the Constitution will have been so satisfied. And then I will go, and let me not forget that we provided that where it is impracticable to file processes electronically, the same may be filed at the registry of the court, so that we know the state of our technology and connectivity, and so not to leave anything out to electronically. Come and file them in the court premises. And I think that will plug in the gap. Now, the Chief Registrar shall designate appropriate officials who shall assess the fees payable by parties and communicate same to them by email, WhatsApp, or text message. We have decided to roll out a gazette of this scale of fees, and then if you want to pay electronically, I haven't had them, it will be seamless. You just pay electronically, and then you obtain your receipts electronically too. And we are also updated here on our site electronically, and then the life of the case can begin, or the application can begin seamlessly. Now, I won't like to waste time on assessment of payments and things like that, which I've just mentioned. The email address and contact telephone number of the registry, like I said, would have been made available on the Judicial Information System and the Judiciary website. Now, notwithstanding the provisions of the High Courts of Lagos State Civil Procedure Rules 2019, as well as the Comparative Magistrate Court Civil Procedure Rules, service of processes may be effected by email, WhatsApp, or as directed by the court. This is to allow for a situation where parties agree on another mode of service. Once they agree on it, and the court sees that to create any problem, the judge or magistrate may allow it. And that way, the issue of service is minimum. We also provided that service of processes shall be proved by filing an affidavit exhibiting a printout from the electronic device used in sending the process and showing the date and time of receipt of same by the other party. Well, after so much deliberation by the body of judges along with some of our senior magistrates, we also came up with that paragraph 13 there, where we said, where an electronic mode of service is employed, time shall prima facie, I will explain that, time shall prima facie begin to run from the day the process was sent. And we use the word prima facie there guardedly so as to provide for situations where there might be disputes as to when processes were actually received. There may not be dispute as to when it's sent. The sender will know when he or she sent it. But the person receiving it may be the one to dispute. Oh, it was sent on Monday. No, I got it on Thursday. So that's why we use the word prima facie there. If such a dispute arises, then there can be further inquiry as
Hello?
And we lost his lordship.
Yeah, so I can't hear my lord anymore, and but can you still hear me?
Yes, we can hear you. Maybe we've lost, lost the CJ.
I'm sure the signals will come back. I think it's probably likely to be a network problem.
Yeah.
The same network, eh?
So I think it appears we've lost my lord right now because he's gone off the screen completely.
He's back on. He's back.
On. All right.
His microphone is muted.
Okay. My lord, I think your mic is muted. If you can please unmute. Thank you very much, sir.
Thank you. Can you hear me now?
Yes, sir.
Yes, very clear.
We can hear you.
Sorry, and that's please, you may note that as well. There's a loss of connectivity as to its consequence. Gentlemen and ladies, there will discuss later. Maybe that was a practical demonstration of what will happen.
Absolutely.
Now, remote hearings we said here shall be by Zoom, which we are using now, Skype for business, or any other video communication method. And there's something that the court could provide. We will go ahead with you in ensuring that the hearings are conducted timelessly too. Now, we said that before the court orders a remote hearing, the registry will liaise with all counsel on record to ensure that suitable facilities are available. The court shall thereafter direct an appropriate remote communication method for the hearing, or where impossible or not agreed, an adjournment of the case if a remote hearing is not possible. And the notice of the remote hearing shall also be stated on the court list and the judiciary website, as I earlier said, and shall be communicated to counsel and or parties by email, WhatsApp, or any other electronic means as the court may direct. Now, so the conduct of the proceedings in the court shall give directions to parties during remote hearings on the use of video and audio during proceedings. This is targeted at ensuring that the official record, the authentic record of proceedings, will be one made by the court. No party will be allowed to do personal recording, either audio or video. And in any case, because of the state of technology, we know that some may still be able to breach this. What we are saying there is that in any case, and at the end of the day, it is the record of the court that will be the authentic record of proceedings. Of course, where, as you lawyers used to do, where you want to dispute records of the court, you know the proper procedure to take. Like I said earlier, Shasore, you are laughing at that. Like I said,
no, I don't.
You can take the necessary procedure to do that. So that opportunity is not taken away from you. So there cannot be any complaint about the denial of fair hearing on that. Now the counsel, hello, I guess I'm still with you. I guess I'm still with you.
Yes,
yeah, we can hear you.
Thank you very much.
We can hear you, my lord.
And we also provided that counsel shall dress appropriately and parties shall be properly dressed for court proceedings. You will know that we had provided earlier that the judge or magistrate will sit in open court. We had come to that conclusion because of the plethora of judicial pronouncement by this apex court on what is a public hearing or a court hearing. So in order to obviate any unnecessary criticism on that as to affect the validity of proceedings, we have intimated that every judge or magistrate will sit in open court for the proceedings. So if a judge is robed, I guess it follows that the lawyer too must be robed. It equally follows that as in the ordinary courts, physical courts, parties too will dress properly. So the several observations raised as to improper dressing, these rules, these practice directions are really taken care of. So we may not have any problem with that. Now, we also provided for recording, I think I had mentioned that recording of proceedings by counsel and of parties shall only be with the leave of court. And then at the end of proceedings, certified copies of proceedings shall be made available upon request, as is the case in the normal physical court sittings. Now we came to adoption of written addresses. And adoption of written addresses we provided shall be in compliance with the provisions of the rules of court. You move your application, you will have already filed your written addresses along, and then you just move your application, you adopt your addresses. The opportunity to do oral adumbration is still there. But if parties agree, and maybe because of availability of time on this kind of proceedings, now we also provided that oral argument of such written briefs may be dispensed with if parties agree, so that nobody will complain of having been shortchanged, just like what was done to Taiwo earlier on in these proceedings. Now, notice of delivery of judgments or ruling provides that the court shall, through the registry, notify counsel and or parties by email or WhatsApp of the date reserved for the delivery of judgments or rulings. And that's in a case where the judge or magistrate did not deliver his ruling or judgment right there on the bench. Normally, you'll be notified of the dates. And all dates, when remote hearings shall come up, and for whatever proceedings, all will still be put on the cost list and on the judiciary website, as I earlier stated, so that from the beginning of the matter up to the conclusion of that matter, all the parties, queer counsel, parties or witnesses, and every other person who is interested in watching those proceedings will have notice from the beginning to the end. That's how much we have said. But let me now, outside the provisions of the directions, react to some criticisms. These rules were like emergency rules made for emergency situations. But it has become clear to us that this is the way to go. And like I said, I and the Attorney General have been fervently working on our e-court in Lagos State. And this just came in now to tell us that we may need to fast track that, and we certainly will do so. And as to hearing of cases in full, issues have been raised as to cross-examination, tendering of documents, and other proceedings like that. My own take is that as for cross-examination, there should be no difficulty at all. I will also mention management of documents, which will normally feature in trials. But let me take cross-examination first. We are all seeing ourselves there. Once the parties are seen, all the counsel are seen from their different locations. Now, I don't see any difficulty in counsel cross-examining witness, or in counsel raising objections, or delivering addresses in respect of the proceedings. What could arise and which might be problematic is the issue of tendering documents. Tendering documents and probably objections to documents. Taiwo, let me say, because I don't want you to sue me for plagiarism. When we discussed, you told me that for your arbitration proceedings, you asked a provision like the manager of documents. For the high courts or the courts, we will have had case management conferences. Using this methodology of hearing now makes that particular stage of proceedings much more important and much more critical to be properly utilized. At case management conference, parties could settle on which documents they are not objecting to. Those are taken apart. Those are marked down by the courts, not necessarily as exhibits, but they are given a nomenclature, maybe 1, 2, 3, all the documents we now know. Deed of assignment 1992 is exhibit number 1, document number 1. So that when you come to trial, those that are not objected to are taken in seamlessly. Those that are objected to will also have been dealt with as CMC. At that point in time, and we will look back into our rules of court to see whether this is allowed as the rules are presently couched, or we need to tinker with the rules maybe by way of further practice directions. Those objected to, both counsel can argue on them, the judge can write his ruling on them, and then they are resolved one way or the other. But what I see in that again, as something that may come up, is that as usual, lawyers where they don't agree with such rulings will say they want to appeal, and then they want stay of proceedings. These are things you erudite persons there will discuss. But as the judge, we will listen to you, and then we can, on both sides, chart the way forward. Now, we also intend to do something like you have been doing in arbitral and other non-formal court proceedings with respect to management of documents, so that when it comes to the real trial, we'll be able to get over this as seamless as possible. The other issue, I think I will stop at that for now, and probably may react to issues raised later. Thank you very much.
My Lord, the Honorable Chief Judge, thank you very much. You raised a number of issues which indeed some of our panelists today are going to be addressed. And in fact, on the chat facility of this platform, I have seen some questions being put across that anticipate some of the questions you have raised. So my Lord, thank you very much. I'm sure you'll get the opportunity to respond further to those questions. Thank you very much, my Lord. So at this point, I will give the floor to Honorable Justice Oshodi, who is going to be exploring the question, restoring full services in justice delivery, scaling up the use of virtual hearings. My Lord, Honorable Justice Oshodi, the floor is yours.
I'm sure we can now hear me. Hello?
Yes.
Yes,
yes, we can hear you, my Lord. We can
Yes,
hear
my
you.
Lord. Yes, my Lord.
Good afternoon. Good afternoon, my Lord, the Honorable Chief Judge, ladies and lords here present. The Honorable Attorney General and SLC, your honors, members of the bar, the participants, and all stakeholders here present, ladies and gentlemen. The topic highlighted for me to discuss is restoring full service in justice delivery, scaling up the use of virtual hearing. I must confess that the word restoring used in the context of virtual hearing in justice delivery in Nigeria is a bit misleading. This would suggest that there had earlier been virtual hearing judicial proceedings before today. This is not. As it is well aware, Lagos State Judiciary has an information system named Judicial Information System, GIS. This system came online on 2nd October 2013. As from that date, any case filed at the Higher Court is captured in this system through e-filing, pursuant to the practice direction issued by the Honorable Chief Judge then, Honorable Justice Phillips. In that year, October to December 2013, a total of 1512 cases were filed by way of e-filing, and for subsequent years till date, I beg you, I need to give you the stats for a reason. 2014, 6,445 cases, 2015, 7,080 cases, 2016, 8,046 cases, 2017, 8,708 cases, 2018, 8,318, 2019, 7,800, 2020 till date, 2,005 cases. From the stats provided above, it can be seen that an average of 8,000 cases are filed in a year, which has to be distributed to about 60 honorable judges sitting within Lagos State Judiciary. This roughly comes to about 134 cases per each judge per year. Now, with the outbreak of this pandemic, COVID-19, the court has been under lockdown and nothing substantial had been done. There's been a lot of debate whether the court ought to conduct proceedings virtually, and various comparisons have been made with different jurisdictions abroad. While this is a nice concept, we must have in mind the peculiarities of our own setting, that is, the law upon which the courts draw up their judicial powers. The crucial law here is the provision of Section 33 of the Constitution as amended. This section deals with the right to fair hearing. I am sure we all participating today will appreciate the importance of the right to fair hearing in our justice delivery. In Baba versus NCATC, citation 1991, 5 Endobera, part 192, page 388, the Apex Court held that for an hearing to be fair, it must include the right of the person to be affected, 1, to be present all through the proceedings and hear the evidence against him, 2, to cross-examine or otherwise confront or contradict all witnesses that testify against him, 3, to have read before him all documents tendered in evidence. My Lord the CJ, please, if you can mute your speaker, sir. If you can mute your speaker, sir. 3, to have read before him all the documents tendered in evidence at hearing. 4, to have disclosed to him the nature of all relevant material evidence, including documentary and real evidence prejudicial to the parties save in recognized exceptions. 5, to know the case he has to meet at the hearing and have adequate opportunity to prepare for his defense, and to give evidence by himself, call witness if he likes, and make oral submissions. Then Section 36(3) of the section provides as follows: the proceedings of a court or proceedings of any tribunal relating to the matters mentioned in subsection 1 of this section, including the announcement of the decisions of the court or tribunal, shall be held in public. There are many decisions of the Apex Court on this latter provision of the Constitution, notably Misiru, Alimi and others versus Asani, Koshebinu and others, 2016, LPELR 42557, Supreme Court. Now, it is not my duty to critique this position of the law vis-a-vis virtual hearing, as I can see that both Messrs. Shasore, Essien, and Miannaya, Essien will do the honors later. I have checked but cannot find the meaning of virtual hearing in all the websites I visited. However, virtual hearing can be described as a hearing done remotely with the aid of technology, whereby participants can state their respective case in their remote locations without physically being within the courtroom. That is, hearings conducted online, real time. Now, is it feasible for courts to use virtual hearing for some of these proceedings? My answer to that is a yes, but our rules of court ought to be amended to include provisions that will enable the court to so do. For example, a look at Part 5 of the Civil Procedure Rules of the United Kingdom, which deals with court documents and electronic mechanical signatures, may be helpful. I am aware that the President's direction can also cure this, which the Honorable Chief Judge had issued and is enforced as a date. In truth, hearing proceedings virtually is not a feat that cannot be overcome. The minimal infrastructure to enable such hearing are in place and not necessarily an add-on, which will incur further costs. The internet connectivity is good, at least in Lagos, and there are smartphones available for most of us. Most of us have the smartphones which are internet enabled. We are all aware of the Zoom. We are all aware of Zoom, Skype Business, Google Meet, GoToMeeting, Microsoft Teams, and various other applications in store. In reality, and in my view, taking into consideration our jurisprudence, the cases that will be appropriate for hearing virtually ought to be cases bordering on fundamental human rights, cases commenced by way of applications where affidavit evidence is the source of evidence and applications for bail. where the presence of the defendants can be dispensed with. From the stats mentioned above, the total suits which are by way of application filed this year is 343. I am very sure that if these applications were taken or added virtually, over 80% would have been dispensed with by now. In this respect, once all the processes have been filed and the Honorable Judge is ready to take it, counsels who must have endorsed their contacts on the processes filed by them will be notified electronically of the virtual hearing. It is suggested that this notice also be posted on the judiciary website and cause list for the attention of the public. Once counsels have been notified, the virtual hearing can be conducted and, if possible, a ruling judgment delivered on the same day, since the documents to be considered are before the courts. With this scenario, the Honorable Judge will only see counsels on such matters through video, and a lot of time will be saved by all concerned. This is also comply with the social distancing policy. The practice direction as issued by the Honorable Chief Judge will take care and has taken care of all the preliminaries from filing to hearing. It is robust enough. However, for trials in criminal matters or trials in civil matters, where the demeanor of witnesses is key, especially during cross-examination, it is my view that virtual hearing will not be appropriate and may constitute a breach of the principle of fair hearing as brought up before. I should also add at this point that as a date, the Controller General of the Correctional Facilities has directed that no inmate is brought to court for now. In this instance, I would suggest that rulings and judgments may be delivered through virtual hearing in criminal matters, with the defendant being present remotely at the correctional facility. I do not think this will constitute a breach of fair hearing for a defendant in custody. But for the defendant on bail, his presence physically in court cannot be excused. Going on, the use of virtual hearing may limit the legal representatives' interactions with their own clients, who, for example, cannot easily pass notes forward or have a quick discussion during trial. These micro-interactions shape the social dimensions of our justice system, and it is not easy to replicate this via virtual hearing. The only exception here is where a witness is not within jurisdiction, and to save time and cost, upon an application of either counsel, such witness may give his or her evidence virtually. The advantage here is that legal practitioners will be able to read the judge's reaction and act accordingly, which is key in any hearing and proceedings by video link. In addition, it is possible for the hearing to be recorded and also made available to the public. The added advantage is that for those legal practitioners who are also participating as observers on mute and with no video, being on one's laptop means efficient access to all the documents that may not ordinarily be the case if they had attended the court with only key documents in hand. Given the uncertainty with the current situation, it is clear that virtual hearing is the way forward in order to allow for the administration of justice to continue. There are significant cost savings for all parties involved, including moving forward in relation to the preparation of electronic bundles over hard copy bundles. For virtual hearing, there is greater flexibility of process, no travel time, or costs associated with attending a distant court. It is arguably less intimidating and possibly more comfortable for participants as they dial in from their own home or offices. In concluding, I will say without fear that Lagos State Judiciary is ready to conduct hearing virtually if given the green light by the relevant authority and support from learned councils, including the seniors. Still, care must be taken in relation to how technology is incorporated into the existing justice system to ensure that people do not feel as confident using it, to ensure that the people who do not feel as confident using it are not left behind. Lastly, may I direct our attention to the principle of salus populi suprema lex esto, which translated means the health, welfare, good, salvation, felicity of the people should be the supreme law. Let the good or safety of the people be the supreme or highest law, or the welfare of the people shall be supreme law. Is a maxim or principle found in serious the legal books. The benefits of virtual hearing is all for us. Thank you very much.
Thank you very much, my Lord, the Honorable Justice Oshodi. That was a very enlightening presentation. It raised questions, a good number of them constitutional, and I'm very happy that we have a constitutional panel here today that will be able to take those points that you have raised in their presentations. Before we move on to the panelists who will dissect some of the questions, evidential, constitutional, and even some more questions that we have been receiving on the chat facility of this platform, I will hand over the floor to two gentlemen, Dan Wilmot of Stewards and Joe Al-Khayat, a founder of Resolve Disputes Online. We are very much behind time, so gentlemen, Dan and Joe, I would urge, if it's possible, for you to keep your presentations within 10 minutes each. I know that's you know, springing that on you at this time is terribly unfair, but please, just to help us catch up with time. So if you can both explore the subjects that we are going to be talking about: e-filing, e-service, video conferencing, document management, recording and transcribing, it will help to answer some of the questions that we've been receiving on the chat group. Thank you very much. So I'll give you the floor, Dan.
Thank you very much, Tunde. And I am always one who enjoys a challenge, and you have set one, so I shall do my best. Ladies and gentlemen, perhaps to save time, I shall just borrow the greetings that others have extended to those distinguished guests with whom I share this panel and others who are listening. Needless to say, it's a delight to have been invited, and I'm very honored to be able to contribute my thoughts to this. My slot is short, so forgive me for exceeding at an expedited pace. No doubt if I miss anything or if there's anything that's unclear, questions will be asked of me at the end. And of course, I'm always happy to answer anything by email thereafter. I shall very quickly set out some thoughts on the 5 topics that are asked of me. Joe will follow thereafter with his thoughts too, no doubt, from a more technological perspective. My observations I will draw from my experience before the English courts and what has recently happened, and including then, as Tunde has already prefaced, the experience of my colleague attending the English Commercial Court's first ever fully virtual hearing. Very briefly about me, I am a partner in Schurtz's International Arbitration Team, and I'm a specialist in Africa-related disputes. My firm is disputes only. We are some 70-odd partners, 400 personnel, and so we have a lot of disputes experience amongst us, and now we can add to that virtual hearing experience as well. That hearing in particular, just to set the context, was a 4-day hearing listed in late March in the English Commercial Court. Our client was the Republic of Kazakhstan, a state, and we were defending our client against an application to enforce an arbitration award against it of some $500 million US. As I say, a 4-day trial. It was due to have witnesses of fact, experts and clients traveling into the UK from places as far as Kazakhstan, the USA and Belgium. Clearly, when the crisis hit and travel restrictions were imposed, that made attending the trial in person impossible. It was a contested application to turn the hearing into a virtual hearing, one that I'm pleased to say that we won. And as I will come on to, there is now a body of jurisprudence before the English courts as to when a hearing might be suitable to be proceeded on a virtual basis, and when perhaps it nonetheless would be suitable to be adjourned until such time as it can take place in person. Turning then to the 5 topics, I might start with video conferencing, because clearly that is a major part of the solution that we are exploring today. As has been commented already, the use of video technology in dispute resolution is nothing new. It has to date largely been restricted to the presentation of witness evidence when a witness is unable to attend. And certainly in the UK, whether in court proceedings or in arbitration, how that is done is very much done on a case-by-case basis and subject to the discretion of the judges or the tribunal, and often is led by party proposal. Of course, now in the face of the crisis, video conferencing technology is more widely used. The UK on the 16th of March was put into its first phase of complete lockdown, and 3 days later, the Lord Chief Justice of the English courts made very clear that in his view, the default position in all branches of the judiciary and the court system would be that hearings must be conducted with more than one, or indeed with all attendees participating remotely, so as to allow the administration of justice to continue. That statement was made with the support of political will and legislation that no doubt assisted the Lord Chief Justice in making the statement that he did. But the position today is that it is almost business as usual. I say almost because certain cases are just not suitable to being progressed as a virtual hearing, large jury trials, for example, or certain family matters. But certainly those are the exceptions rather than the rule, and the starting point in the English jurisdiction is that hearings must proceed on a virtual basis absent good reason otherwise. What might constitute that good reason? Well, that sits within the discretion of the court, the judge, allocated to the particular matter in question. But I should say that the judges are exercising their discretion in a very narrow fashion. We have already seen recently an application for a 5-week complex hearing that is due to take place in June. An application for adjournment be dismissed. That trial will now proceed on a virtual basis. We are seeing a growing body of jurisprudence as to how judges ought to exercise their discretion as to whether to adjourn or to allow to proceed on a virtual basis. Arguments such as poor internet connectivity, insufficient staff in situ to assist from a technological perspective, no access to hard copy documents, or indeed having to care for loved ones at home are not being accepted on their own as good enough grounds to satisfy an application for adjournment. So far, the jurisprudence is developing, but where cases are being adjourned broadly fall into 2 categories. One is where both parties to a dispute agree. And whilst it remains always open to the judge, nonetheless, to insist on a virtual hearing, both parties agreeing is strong evidence to the judge that he or she ought to exercise their discretion accordingly. The second category is broadly can be summarized as where there is a concern about the ability either to control the witness environment or given the nature of evidence that is required in the hearing. If there are complex matters of fact, if there is likely to be extensive and arduous cross-examination, or if the nature of the witness itself or the nature of the allegation put to the witness, such as fraud or dishonesty, is part of the case, then a judge may exercise their discretion to defer the hearing and hold it in person instead. To support the court exercising those judgments and its discretion, significant guidance has been issued, including listing priorities, including factors to be considered in the exercise of discretion, including guidance on the practicalities of remote hearing. Because what is key that we have learned is that the imposition of virtual hearings and the support of the participants in the process must be led by the judiciary. They must feel comfortable with it. They must lead by example and effectively hold counsel to task to not raise excuses and to explore all options that may be available so as to allow the administration of justice. And so with that in mind, I was very pleased to hear the very good commentary made by earlier contributors about sort of the extensive and comprehensiveness of the practice directions that have recently been published. Very quickly, our experience of the virtual hearing that my team went through was very positive. As has already been expressed, the technology exists. It is there, we are using it right now. There are 517 participants currently on this platform, and it is running broadly smoothly. Some points that we drew out, however: there needs to be good speaking discipline. This technology is not so good at allowing 2 people to speak at the same time. And when one has court transcribers and translators, that must be borne in mind. There needs to be, in my view, a witness protocol agreed between the judge and the parties as to how witness evidence is to be delivered, the practicalities around it. How is an oath to be sworn? How is a witness to not discuss their evidence whilst giving it during a break? How are you to ensure that a witness is not being coached from behind the scenes as they give their evidence? Now, things can become very complicated when trying to come up with difficult solutions to these difficult problems. There are always simple solutions, however, I suggest. For example, a witness simply turning their camera 360 degrees in a room before they start testifying can often reveal if there's any other culprit in the room. So these things need not be overthought. Internet connectivity was an issue at one point in our hearing. However, our expert who was testifying reconnected to Zoom over 4G with their internet, with their mobile phone, and that worked adequately. So it isn't the only problem that may arise. We had a third party who supported the process, a third party who had control who was admitted into the hearing room, who would test audio, test video, and who would remind participants if, for example, their microphone was on mute. We thought that was very helpful. And I put the question to everyone, is the modern court clerk actually an IT technician now, above everything else? Finally, channels of communication. During the hearing, of course, advocates had to consult with their instructing solicitors, if that were indeed the case, their clients, their witnesses, their experts, where permissible. We found that using WhatsApp, the web online version, on a separate screen proved perfectly adequate to allow that discourse to take place. And so overall, the feedback was very positive indeed. Turning now to some of the other topics very quickly. Document management. The English courts and indeed arbitration are no stranger to electronic bundling, to the electronic submission and presentation of evidence. There are varying levels of functionality available. Joe, I'm sure, will talk about that in his session, but solutions can be simple as a PDF, which is shared with everyone in advance, which is paginated. Zoom, as we may see today, has screen sharing abilities, where one can pull up a document on screen that everyone sees. That can actually tick the box of document presentation quite nicely. Again, we have found that a third-party operator who can control the electronic bundle, who can bring up a document on the screens of everyone, can very much facilitate proceedings and ensure that everyone knows what document everyone is looking at. And as maybe has been suggested already, multiple screens are key. It is a small investment, but it significantly increases productivity to have a second screen available. Moving on to recording and transcription. I noted some of the comments about the practice direction have addressed this. The UK has a similar prohibition on recording of proceedings, which dates back from the 1920s. I need not go into why that is the case, but we now have a legislative exception that has been passed to allow effectively to allow the recording or the transmission of proceedings on a virtual basis. Query whether that prohibition will ever be resumed once we are out of this crisis. I think the concept of giving access to open justice must now be interpreted in the modern day. Indeed, in our case, our hearing was streamed live over YouTube so that participants, so that the public could watch proceedings. And I would draw a distinction between the need to allow the public to attend the very same Zoom platform upon which the hearing is taking place, or indeed any other platform, versus the ability to then stream what is taking place on the platform on another facility. E-filing, very briefly, that was launched in the English courts in October 2014 as a pilot, and incrementally it has been extended to almost all of the senior courts now in the English jurisdiction. We use a bespoke piece of software developed for the courts, and it has been very successful. Claims are issued, court fees are paid, and all subsequent court documentation, whether it's application notices, submissions, witness evidence, or otherwise, are all uploaded and managed on that facility. We no longer have paper copies. Indeed, it's a two-way facility such that once a claim is issued, the judge will seal it electronically, and in fact, it is the PDF downloaded version that is then used for service. We have no wet ink anymore on these documents. It has been very successful. So I was very pleased to hear that that is under consideration as well, because we have seen that being a significant improvement. Lastly, on e-service, we do not, as of yet in this jurisdiction, permit e-service using the same facility for e-filing. Service is separately regulated in accordance with the court rules. Those rules have for some time anticipated service by way of electronic means, whether by fax or more commonly email. However, that is done on a consensual basis only. So your opponent has to agree to accept service by way of email in order for service to be effective. That is done for a number of reasons, and we have seen actually during the crisis a number of entities now proactively state that they will accept service electronically simply because they are having difficulty in accessing their post, which is sat in their office somewhere away from their home. That said, it is always open to the court to agree alternative forms of service, and no doubt you would have heard the stories about service over Facebook and other social media and otherwise in exceptional cases. Some very quick concluding thoughts to hopefully help promote the debate. Some anecdotal feedbacks now that we are 6 weeks, 2 months into the use of virtual hearings heavily in this jurisdiction. We are seeing clients feeling that they are not having their day in court. They like the formality of turning up to a dusty courtroom, seeing everyone robed, and seeing all the papers. Justice must not only be done, but must be seen to be done. And so I think it goes hand in hand with the comments made by my lord earlier on this conference, that there is a need to remain robed. There is a need to retain formality in proceedings, notwithstanding that one might only be wearing a suit in the top half and maybe wearing their pajamas in the lower half of the camera. There is a growing recognition that virtual attention is tiring. It is more tiring to watch a hearing on Zoom than it is to watch a hearing in person. So whilst we are seeing that hearings are not taking longer on a virtual basis, few are being able to be done on a daily basis. Our judges are tired. There are, I'm sure, a number of reasons for that, but electronic hearing is clearly one of them. So I think that needs to be taken into account in listing priorities. And finally, I would just reiterate that virtual hearings are an answer to the crisis, but they may not be an answer forever. There are certain cases that may not be suitable. I've mentioned some, there are others. For example, how does one do a site inspection in a virtual capacity? How does one pull up a demonstrative? How does one hot tub experts, whereby you have experts from both sides giving evidence simultaneously? There are some difficulties there, but still, I do believe there is value in what I call the technological revolution. Virtual hearings may not always be the answer, but the use of technology in the ways that have been described, I believe, are always the answer. The virtual e-filing, case management, e-bundling, the delivery of evidence by witnesses virtually. So I would suggest that whilst an investment has to be made, not just in the infrastructure, an investment has to be made in training, and most importantly, in resetting cultural norms. We have to be used to using these systems and want to use these systems. I believe there is a future-proof option here available. So I'm very pleased to see sort of the evolution of this discussion in your jurisdiction. Thank you very much.
Dan, thank you very much. You've touched on a number of the issues that some of our participants had actually put across in their messages on the messaging service. I will hand over to Joe now, but just before I do that, just to acknowledge again, this platform is being provided by the Ministry of Justice, Lagos State, CRID-LawNet, and the Justice Reform Project. And I also want to acknowledge the presence of a lot of our lords and ladies and worships who are attending this event today. Joe, I will now hand over to you. And one question that has arisen in circumstances where, like Dan mentioned just now, a party actually accepts to receive service by email and then denies receipt later on the basis that there was a technical glitch. What facilities exist for ensuring that you are able to establish that in fact that party did receive the email? Just take that on board in some of the things you are going to discuss to the audience today. So Joe Al-Khayat of Resolve Disputes Online, a company that specializes in providing online dispute resolution services to courts and public institutions and arbitrations. I hand the floor to you now, Joe. Thank you very much.
Thanks, Tunde, and a real honor and a real privilege to be here and sharing the platform with so many distinguished guests and so many distinguished guests who have been speaking an awful lot of sense, I have to say, during the passage of this webinar, and most recently the comments of Daniel. I think very sensible, very measured, and how wonderful to have that insight into a very recent case, hearing such new and interesting developments going on in all of these jurisdictions. To keep my session to a 10-minute limit, I will do my best. There's a lot of content that I need to go through, but I'll try and summarize it in the 10 minutes. In summary, as Tunde said, we are dispute resolution technology specialists. Our background prior to that period was as international lawyers. I myself practiced in the United Kingdom and in Australia, and colleagues of mine have practiced in multiple jurisdictions as well. What I'm going to do over the next 9 or so minutes is give a little bit of background about online dispute resolution and virtual hearings. Virtual hearings are more or less a subset of online dispute resolution, which has been existing now for, some would say, 20 years. So I'm really delighted to share a bit of insight into that. And the reason why Resolve Disputes Online started very much pre-COVID-19, 5 years ago, is because of the global access to justice problem, which we all know about from a multitude of jurisdictions, mainly dealing with cost and delay. And the idea behind technology like RDO and other technologies that you'll be hearing about is that one can license or provide this technology to courts, to mediators, to arbitrators, to empower them so they can do dispute resolution better than how they do it now, or at least keep doing it during the present crisis, and ultimately improve global access to justice in doing so. So let me talk briefly about online dispute resolution. So it will, in essence, refer to the use of technology to assist with dispute resolution. And historically, it's been used in negotiation, mediation, and arbitration. So in ADR, in the arena of civil matters. And its genesis was essentially through e-commerce. So the big e-commerce platforms of the late 90s were the ones that realized they had so many disputes, they needed to work out how to use it, and they didn't want to be using small claims courts, for example. So that's why these ADR mechanisms were built in. And over the past few years, both ourselves and other technologists have been fortunate enough to be doing some very exciting work in places like the US, the UK, Singapore, Canada, and in Australia, and more recently, an exciting project in Africa. And we're seeing that in the US, for example, the online court process has already started. And it started about 3 years ago. The UK have started with their £1 billion project as well. So there's certainly a huge shift well before the COVID-19 pandemic. And what it essentially does, as Daniel and others have identified, is this technology just leverages many of the technologies we already use, which we associate with convenient, accessible, and ease of use. And we adopt that in a dispute resolution paradigm or setting. And of course, there are challenges to doing that, as we've heard. And some of these examples I'm going to be highlighting today for you, including case triaging tools, file sharing, some artificial intelligence tools, intelligent automation, which is a slightly different facet of that, and video and audio tools, of which we're very familiar with, and we're using one of the main ones now. So in terms of COVID-19, this is when we've seen the scramble for what we call online trial tech, which can be seen perhaps as a distinction to online ADR tech, which appears to have been the theme that really has started off online dispute resolution. It was more or less limited in that context. Very briefly, I don't want to spend too much time on this given the issues that we have in keeping to time, but if we look at a mediation process, for example, and those 11 steps that I've highlighted here involving bookings, payments, venue choices, document exchange, travel, a lot of this can relate to any dispute resolution process. Venue setup, the introductions of a mediator, ground rules, the shuttle mediation process going between rooms and drawing up settlement. That would be the typical 11-step process, subject to nuances that may exist in certain case categories and jurisdictions. But what one can begin to do when they look at that from an online process on the right-hand side is these steps begin to conflate. They begin to simplify. You know, the idea of registering and payment can be seen in e-filing, how one can file a case and pay for it there and then. The document exchange or the service of documents can be done through certain platforms. And then you've got the communication piece, which can happen live as we're doing now, or using certain tools. One can do asynchronous communication, which is something that the RDO platform allowed. So asynchronous meaning more akin to an email. It wouldn't be instant, it would be communications over a period of time. And then the idea of settlements being drawn at. Technologies like RDO and other technologies can show that settlements can be crafted and they can be electronically signed there and then. Maybe subject again to a consent order and require further enforcement, but ultimately you can draw that document up electronically. So very briefly, running through some examples of ODR technology in action. This would be an example of a court where they would be dealing with high volume speeding matters in this case, where the magistrate would have the ability to be able to draft their judgment or their outcome and be able to fill in various templates, which tends to be the formulaic way that many criminal low-level matters would be dispensed with, and be able to submit those to the parties. So these are examples of certain facets of ODR technology that we see. And moreover, there can be electronic signatures and submissions of those court orders that can go to parties. Very briefly and very much hot off the press is some of the testing that's been undertaken in relation to an AI mediator to help court backlogs. Very briefly on this point, this was a UK sandbox environment test that was undertaken a couple of months ago, where it essentially involved the ability of parties to choose to settle their dispute using an AI mediator. And that was the test that was being undertaken in this matter, where it was a landlord and tenant rental arrears case that was stepped through and registered. And the gentleman who was undertaking the role of the claimant would go into a sandbox environment of the RDO platform and would be immediately messaged by Molly, who is the AI mediator bot, who has the ability to use her algorithm to find zones of potential agreement between parties. And the parties don't need to disclose their offers per se. And upon the parties finding a zone of potential agreement between them, Molly has the ability then to go through and indeed draft up a settlement for them, which is pre-filled. So it has a starting point for the parties then to agree what might be a sensibly worded document in relation to very simple small claims matters. So this is the sort of ODR technology that we're seeing here, and parties can click on the blue button there and can sign the relevant settlement that might be applicable. Human mediation, though, can be applied on any form of suitable ODR technology, whether it's using an end-to-end encrypted chat technology similar to this, where parties can also initiate a video call if they need to, so one can have private messages or private group discussions in a mediation, or in a court matter, all communications can be outlined there in the joint space. So it's giving that flexibility between the instant communication and the asynchronous communication. And following that process, the idea of sharing evidence, or if this is a matter where we're dealing with I think this is going to be a case where the landlord's complaining that the tenant has spilt a very large glass of red wine there on the cream carpet. This sort of evidence can be captured within a portal. One has to make sure that it's secure and it's encrypted, and one can allow this type of technology to guide you through an electronic mediation or an electronic arbitration or trial. One of the beauties, though, of online dispute resolution is with suitable platforms in place that are talking to each other, what courts can do, which they haven't historically been very good at, is being able to draw data on what types of cases they've been doing, what are the trends for the resolution choices, what's the feedback that's been given by users, and collate those and be in a position where they can genuinely make what we would call human-centric or user-centric improvements to the justice system, which has been a criticism, of course, that we design justice systems for lawyers, not necessarily for parties. So I've done a quick look at the past, I've looked at the present, now in terms of the future, looking at key considerations about how that might look. There are, of course, requirements of adopting this technology to suitable cases in the short term. And I'm not going to labour the points that have already been made by distinguished panellists, and most recently Daniel, about what those suitable cases might be. Practice directions are, of course, being put in place very rapidly. But just a point in relation to the consulting that RDO has done relating to video platforms. There is often a compromise between security and what we call UI, UX, user interface, user experience. Often it can mean that parties that choose the most secure video conferencing solutions sometimes miss out on a more intuitive user experience. The platform that we're using now has had its own challenges, of course, in COVID-19, where because of the absence of secure link sharing and security, the notion of video bombing, or more specifically Zoom bombing, became a phenomena during the month of April. They had to take very swift action. There are other video platforms that are extremely high-level encrypted that are used by the military, for example, but the user experience on those is much more challenged. And for that reason, it may well be that certain courts might need to choose video platforms that are more intuitive to be able to use by less, shall we say, non-tech savvy people. In terms of what your strategy needs to look like, in the short term, it's about getting suitable cases heard to ensure that justice is not delayed, which of course is the risk of the current crisis. But ultimately, look beyond COVID-19. What we refer to in jurisdictions like the US and what we refer to in jurisdictions in the UK is the court component model, which tends to be a combination of tools, which includes things like e-filing. It will include an ODR platform typically, or more recently would include that. It would include the plugging in of a suitable video platform, which is suitable for certain jurisdictions. Governments have preferences towards different video platforms, and so do states. So it's important that any tool that you're using is able to integrate with those video platforms. And that's the relevance of the point here called API technology. What that means is that the applications that you have can talk to each other via this link that we call API technology that enables all those systems to talk to one another. So one has to be mindful when they're looking in COVID-19 and post-COVID-19 as to what strategy you're going to have in place to be able to make sure that you're getting the right solutions and the right technologies that can actually talk to one another. And in the longer term, and coming back to Tunde's question, I'm mindful of time, coming back to Tunde's question about what would happen if somebody challenged that a particular document wasn't received or an email wasn't sent. The way that we would deal with it now, because servers tend to be centralized, so to give you classic examples at the moment, things like AWS, Amazon Web Services, Microsoft Azure, these are centralized architectures. And what would probably have to happen is there would be a third-party application that would be made to those web providers, and there would be logs as to what emails have been sent, at what times, what has been opened, for example. And then the court would have to take an inference as to whether or not they believe the particular witness, as to whether or not service or documentation has actually been validly served, subject, of course, to practice directions and relevant rules. The reason why this point is relevant to raise at this stage is this, that as we go into the next 5 years and beyond, blockchains which are decentralized networks will be able to automatically validate exactly what has happened, when, and to who, without needing any centralized server to look at that. So if you imagine at the moment, you'd have to go to Google, you'd have to go to Amazon to verify that. You wouldn't know, or one couldn't be 100% sure whether that data has been tampered with. If something is on a blockchain and it's decentralized, it would be what we call as immutable. It wouldn't be possible to tamper with that log or that evidence. So that's very much where we see the long term going in relation to as we start seeing the digitalization of many of these processes of service and other key components of evidence and how they're transferred. And then, of course, the appropriate use of AI. this will certainly be a feature in the next 5 years as to when courts start building out their court component model and they get their basics and their essential components in place, they'll then be looking to gain some of the efficiencies that one can enjoy with artificial intelligence. And I gave you earlier a very quick snapshot as to how one might do that in relation to very high volume but low value cases, low complexity cases. On that note, I would say that the reality is we're probably not going to be going back to normal after COVID-19 in relation to the way hearings are undertaken, into the way justice is undertaken. Stretched mind never regains its original dimensions, and the profession and the justice sector has been stretched considerably in these last couple of months. And to complete my hat trick of cliches, the notion that that necessity is the mother of invention has never been more true when we look at the advancement of online dispute resolution. I think COVID-19 has made more advancements for online dispute resolution in the last 2 months than probably what happened in the last 10 years. So on that note, I shall conclude my session, and thank you all for your attention.
Joe, thank you very much. That again was very exciting. I note your prediction that blockchain technology will make it even easier in future to prove that a document has been served on someone. There's a question that one of our participants has put across on the messaging service, on the Q&A service, and it was put across specifically to my Lord, the Honorable Chief Judge, and that's that when we use technology, how are we going to be able to prove that all witnesses have gone out of sight and out of hearing? So my Lord, I don't know if you want to quickly take that before we go into the next session with Professor Taiwo Oshikpiton, Essien, and Mrs. Funke Agbor, Essien. But maybe, my Lord, we want to quickly take that point before we go on. Thank you very much, my Lord.
Thank you, Tunde. Well, I want to cast my mind back to the first video conferencing sitting that I did. Well, somehow the practitioner in me kept being suspicious of what could be going around in the somebody somewhere giving documents in a manner as to answer his questions. So what I simply did was, and let me admit that that would not have been 100% full. Where the witness testified from should be shown to me on video. But that was shown to me, and naturally that was at the beginning of his testimony. Well, as the proceedings went on, there was no way I could have been watching out for that all the time, the four corners of the room where I was testifying. That may be an area where we may need to do more. But I don't see how any court can do much more than that, other than requesting that I want to see the full environment where this witness testifying is giving his evidence from. But let me quickly chip in this so that we don't miss it. And I can see Taiwo there. We don't want him to run away with, not Taiwo now. Taiwo, you are raising up your head. I said Taiwo. And he knows himself. Now, Section 84 of the Evidence Act. How does it affect virtual hearings? Thank you. The experts are there to answer us. Thank you.
Thank you very much, my Lord. And again, I guess when we get to the point in Q&A, we'll also put to the technological experts, Joe and Dan, to some extent, you know, if there's any role that 360-degree cameras can play in ensuring that all witnesses are out of court and out of hearing. But in any event, I will now hand over to Professor Taiwo Oshikpiton and Mrs. Funke Agbor to address us. We have 20 minutes on the clock, but if it's possible to do it in less time than that, I'd be very grateful. Evidential problems in virtual hearings, and you've had some of the questions that have been raised already in the course of this this workshop. So Professor Osipitan, I give the floor to you. Thank you very much.
Hello, my Lord, the CJ of Lagos State and other participants. Well, thank you for the opportunity to participate in the workshop. Mrs. Agbor and I had looked at the various issues, and we identified about 3 issues as they affect the law of evidence. One is the fact that when we talk about virtual hearing in law of evidence, we are looking at as a situation where it has been agreed by the parties or directed by the court that this particular trial, which is for oral hearing, must go on through remote hearing. We looked at the other cases like instances where you rely on affidavit evidence for motions, originating motions, and originating summons. And we took the view that virtual hearing of those applications or causes is the way to go. Now, the area we are discussing is virtual hearing in cases commenced by writ of summons, where evidence will be taken. We also identified that for evidence, there are 3 aspects of it: oral evidence, and real evidence. I would take documentary evidence and real evidence to conserve time and yield the floor to Mrs. Agbor to look at oral evidence, oath-taking, and demeanor of witnesses. But one problem we identified is that when you talk about evidential problem, you are mentioning the word evidence. And when you mention the word evidence, our mind went straight to the lawmaking powers of the state over evidential issues. I say so, or we say so, because of the Constitution. Under the exclusive list, you have evidence coming on under as item 23. If that is the case, we looked at whether practice direction is the way to go in terms of how to ensure virtual hearing using oral evidence and documentary evidence. But happily, we were able to also show that evidence appears like a beautiful bride. It belongs to the National Assembly to make laws on, but it also falls under practice and procedure. So we concluded that it is safe to go that way and see that the practice directive can be amended in a way that will ensure that we achieve virtual hearing within the limits of the law, without necessarily going outside the Evidence Act, but acting under practice and procedure. Having done that, I looked at the issue of documentary evidence. And in documentary evidence, we looked at the issue of primary evidence and secondary evidence. We also looked at the issue of public documents. How do you tender them? We are all used to a situation where the counsel comes to court with all his documents and is showing them one by one to the client, to the witness. And after identifying them, laying foundation if necessary, then those documents are tendered. But for virtual hearing, there will be a paradigm shift because it is not possible for the counsel and the witness to all be in court. The opposing counsel will be somewhere else. So how do we ensure that these documents are tendered? I believe that you will need, obviously, some case management strategy. And I share the experience of the Election Petition Tribunal, where all the documents are front-loaded, like you have in the High Court of Lagos State. It is compulsory that you must front-load your documents and also your list of witnesses. Also, in magistrate courts, there is no provision for fraud loading, but in practice, I understand the magistrate also follow that procedure. So the rules will have to be made applicable to both the magistrate courts and the high courts. Now, if these documents are fraud loaded, then on a particular day, the counsel to both parties will have to meet and have documents agreed upon. where they manage to agree on all their documents, then the report is forwarded to the trial judge that we have agreed to admit the following documents. And those documents are marked by them or by the court. Now, on the day of the trial, those marked documents are read out to all parties. That documents that are at pages 1 to 5 of the bundle of documents are admitted by consent as Exhibit A. Pages 6 to 10, Exhibit B, and so on and so forth. And once they have been admitted, then they are duplicated in the sense that electronically and also otherwise, so that when the trial begins, the counsel is asking the witness to acknowledge those documents listed as number 1 to 5 of the bundle of documents. Once he acknowledges them, then they are taken as admitted and also taken as read. There will be a paradigm shift in terms of us abandoning the rule on dumping of documents. All documents tendered are deemed to be read. Nobody will say, you did not offer oral connecting evidence. So there will be paradigm shift on the status of such evidence where they have been admitted. With respect to documents that are disputed, then we'll have to possibly look at the issue of the documents, though objected to, can be admitted provisionally, so that they go in, but questions could also be asked on those documents under cross-examination. But because all the parties are on the same page, they have those documents have been marked. What will then happen is that such objections to the documents are reserved until the end of the case, and they are taken during trial. If taken during trial, the trial judge in his judgment is at liberty to now look at the objection. If they are sustained, then the documents that are marked provisionally are disregarded. But if the objection is not sustained, then the document is countenanced and the judge will look at it in evaluating this evidence. Again, there are some documents which parties will have admitted by consent. The judge, in his own wisdom, can ask questions that this document that you have tendered through consent, tell me something. This document is a public document. Can you address me on the admissibility of the documents? In so doing, the judge is guided by the fact that parties cannot, by consent, admit a document which is otherwise inadmissible. So by so doing, we will have succeeded in tendering documents without bringing the parties to court. We could also look at maybe screen sharing of documents. If that is the way to go, you could look at it and such documents are screenshot for purpose of deciding whether they are going to be admitted or objected to. The next one we looked at is the issue of real evidence. In other words, visit to locus inco. I must confess that when it comes to criminal cases, it's a difficult one to sell. Virtual hearing will be difficult to sell in the area of locus inco. I say so because of plethora of cases that say that if you must visit the locus inco, then the defendants, the accused persons, no matter their number, must all be present. These are just a symbol of a fair hearing. So it will be difficult for us at this stage to be able to walk out of that rule. We might just need to take evidence at the locus inco for criminal cases, but not so much for civil cases. For civil cases, it is possible to look at it from the angle of the fact that, the parties can agree that if there are conflicts, you could do a video recording of the scene, maybe a land in dispute, and if they agree, then the video recorded scene of the locus can now be played back to all concerned in court, and relevant evidence, relevant questions are asked under cross-examination in terms of for civil cases. But for criminal cases, it might be difficult. So we might say that you might just have to do physical hearing for criminal cases for now. My Lord, Honorable asked a question that the place of Section 84, subsection 1 of the Evidence Act in the virtual hearing. Well, Section 84, subsection 1 does not deal with virtual hearing. It deals with admissibility of documents produced electronically. And all it's saying is that where a document has been produced through an electronic process, then there must be a certificate of trustworthiness of the device that was used in producing such documents, as opposed to being used to do virtual hearing. I think that covers the issue of admissibility of documents and also real evidence. But then the rules of evidence, particularly those that deal with public documents and other issues like admissions and confessions and other judicial notices, are still there. But the aspect discussed is the aspect that deals with how do you tender documents, and both documentary evidence as well as real evidence in a virtual hearing situation. Thank you. I believe Mrs. Agbor will now take over. Thank you.
Yes, Mrs. Agbor, thank you. The floor is yours now. Mrs. Agbor, the floor is yours.
Yes, I was trying to unmute. Thank you very much. And thank you for the opportunity to be part of this eminent panel. I won't waste too much time because I know that time is fast spent, and I will stand on the existing protocols in terms of courtesies to my fellow panelists and to this Honorable CJ and Honorable Attorney General of Lagos State. What I'm going to be discussing is the issue of the demeanor of witnesses and oath-taking. We are all familiar with the process of, or we are all familiar with our jurisprudence and our judicial system, which takes the importance of the trial judge observing the demeanor of the witness in the trial court. It's very, very important here. And there'll be a number of judicial pronouncements on that. Some judges look at it as very significant. Others, depending on the circumstances, may not take it so fulsomely, but in any event, it's quite a significant aspect of our judicial system and the process. Now, and in particular, it's generally considered a peculiar advantage that trial judges have over an appellate court, such that appellate courts are usually very wary of overturning a judgment, particularly in relation to the findings of fact of the trial judge. So which makes the observing of the demeanor of the witness very, very important and worthy of discussion. So the question is, how do you deal with it in a virtual trial? And when we're talking about demeanor, and for a judge being able to assess the credibility of the witness by observing the demeanor of the witness, we're talking about the nonverbal cues that a witness exhibits when he's giving evidence. Nonverbal cues like his voice, the tone, inflections, nuances in language, facial expression, body language, the time it takes him to answer a question and all of that. So in some cases, this is really important. Now, how do you deal with this in a virtual situation? For me, I think the answer is technology, technology, technology. My Lord, the CJ has also alluded to that in one of his comments earlier. He raised the issue that people have complained about the judge will not be able to observe the demeanor of the witness, and that might impact negatively on his ability to come to a fair judgment at the end of the day. So, and also my Lord also referred to the fact that he has been participating in video conferences and is able to see very clearly this witness. So the camera is trained on the witness. Mr. Wilmot has also alluded and contributed to the fact that we should have more cameras in court so that all aspects of the witness can be viewed by the arbiter, the judge, and all those who are participating in virtual hearing. And so technological advancements has made it possible for the cameras to show the face and the features of a witness when he's speaking. So it's easy to determine or able to observe whether he's exhibiting the sort of nonverbal cues that you would see in an in-person trial. So, so technology, all of these things are transitional, and we have to apply it if we want to ensure that these virtual hearings work with a big dose of common sense as well. And this is implicit in how the judges determine whether or not a virtual hearing should be heard or not in any situation. So the other issue that comes about is witnesses, the integrity of where the witness who is being, whose testimony is being heard remotely, whether you can see whether his testimony is going to be tainted because there's somebody else in the room, or you're able to determine whether there's someone coaching him or something like that. Dan has referred to the panning of the camera around the room. We have, Professor Osipitan and I thought perhaps we could have a representative of the opposing party in the room with the witness where he is. It is a virtual hearing. It is a virtual court. So just as you in a physical court, the judge has control of his court, the judge will also have control of his virtual court. So it could be that as part of the administration of justice, you have court officers who are mandated to attend these proceedings where a witness is that is not in person in court. So that might be a suggestion that we could look at. So demeanor of witnesses, I think we don't need to overthink it. Whether a witness is, where a witness is and how to ensure that his testimony, the integrity of his testimony is not in question, we should not overthink it. I think technology and innovation, as Lagos State is trying to push forward, is sufficient to deal with that. The other points I'm supposed to talk about is oath-taking. I don't think oath-taking needs to be overthought either. In an in-person trial, the oath is administered by a registrar, either gives the witness the Holy Quran, if he's a Muslim, the Holy Bible, if he's a Christian, and I see from the Oaths Act that, that if he's a Jew, he holds a copy of the Old Testament. I remember in the old days, if you were an African traditionalist and you followed, I think which is Shango or something, you bite a piece of iron in swearing your oath. So I don't see that in the law, but but basically, this is all that needs to be done. And so, just as in an in-person hearing, a virtual court hearing, you just need to hold up the Quran where you are, or you hold up the Holy Bible where you are, or you hold up the piece of iron where you are and bite it, or you hold up the, if you're a Jew, I don't know any Jews in Nigeria so far, you hold up a copy of the Old Testament, hold it up to the visual perception or the view of everybody and be sworn by it. So as I said, it's just technology and it gets better every day. Tomorrow will be better, the day after is going to be better. And all we need to do is just ensure that, and as a fallout of this sort of discussions, the practice directions will get better and better and better. But we just need to apply a good dose of common sense to it, ensure that where parties have agreed to have a virtual hearing, that it is made possible. Once parties have decided that they want to, I don't think we'll have any problems with it going forward. So I just want to commend Lagos State because they are the vanguard of new developments, innovations in service justice delivery, not just in Lagos State, in Nigeria, because where Lagos State goes, everybody follows. Thank you very much.
Thank you very much, Mrs. Agbor. That was very enlightening. Before I hand over to the next panel, the last panel, Mr. Shasore Essien and Mrs. Miannaya Essien, I want to acknowledge the presence of the Honorable Attorney General of Ogun State. We had invited him to join this panel because yesterday Ogun State launched its own virtual hearing process. And I think there are a number of experiences that we thought it would be useful for him to share on this forum. But before we get to that point, Mr. Oyetibo would like to make one or two comments on the question of evidence, and then we'll hand over to the last panel and then hear from the AG of Ogun State before we take questions and answers. So Mr. Oyetibo, over to you, sir. Thank you very much.
Thanks very much, Tunde. Well, my observation will be for the speakers on evidence, and it has to do with subpoenaed witnesses. And I think, my Lord, the CJ can also look into this. If you issue subpoena on a witness to testify in a virtual hearing, and he accepts the subpoena, but he refuses to go to the either the office of the council at whose instance the subpoena was issued, say a banker, for example, and he decides that he's not going to spend his own data on participating in the virtual hearing. How do we deal with such a situation? Can we look at that? Thanks. Today, I can't hear you today.
No, we can't hear you.
Sorry, I was, that's a mistake I make all the time. I was still on mute. So I was saying thank you very much for that. And I hope that Professor Osipitan and Mrs. Agbor will get a chance to deal with those evidential questions that you raised just now. But now I will move on straight to the next session, which is Mr. Shasore and Mrs. Essien, and they are dealing with constitutional questions. We'll then hear the AG of Ogun State, and then we'll come back to Prof. Osipitan and Mrs. Agbor to deal with the questions that Mr. Oyetibo just raised. So, Mr. Shasore, over to you. The floor is yours.
Thank you very much, Tunde. Myself and Mrs. Mia Essien are going to deal with this constitutional problems that can arise, that could arise, and we'll also deal with certain other practical problems around the effective and smooth hearing of these matters within the constitutional context as well. So I will take the first 10 minutes, probably a bit less, and yield to Mrs. Essien, who will take the last leg of the 10 minutes. It's enough to say, several have said it, but I must add my own congratulations to my Lord the Chief Judge for this great innovation of being able to move the reform of the delivery of justice, in this direction. It gladdens our heart in JRP, and I'm sure every stakeholder within the justice sector. But I think one thing to notice immediately is that it's a recognition of a serious paradigm shift that is absolutely necessary in this environment. That is to see the courts as not a physical place, to see the court building as not just the only place where you can get justice, and to see justice as a service that can be delivered to you in a manner of different ways. The fixation on the buildings and the accompaniment of our system has long held back many reforms that are absolutely necessary. So the visualizing of justice as a service and not a place. There's several constitutional problems. I'll outline the two major ones. One of them is quickly beginning to slip away, but I'll still mention it nevertheless. We expect, as this practice rolls out, typical of practitioners, and I know my lords and ladies listening will, be very smug about the attitude of lawyers, would raise objections, and many people who are reluctant to proceed with matters such as this will look for ways in which they can avoid it. So it's important that we recognize what the pitfalls are and how they have been dealt with by the courts and how this legal framework can deal with them. People have said to me, and I've seen in commentary elsewhere, that, well, throughout the Constitution, there is no mention of either the word virtual courts, virtual justice, or remote hearings, or et cetera, et cetera. And this has been a valid reason for saying, well, it's not provided in the Constitution, it's not provided by any statute. But I think as far back as 1994 in Agbor and SSS, it was well established that the Constitution is an organic document and must always be read within the context of time. And that time will differ from time to time. And so all the issues that have been raised regarding the fact that the words that would now be relied on for virtuality and remoteness do not exist in the context should easily fall away in the light of such decisions. And just to point out, without being too pedantic, that look, the virtuality and remoteness are not always the same. And to also say that we've been involved in remote locations of hearing matters for a while. And I think it was Professor Oshodi before me that mentioned the hearing on a site, the locus in quo, the proceedings conducted in the locus in quo. It's remote from the courtroom. So it's not something that is absolutely alien to our practice to go to a remote location to either take evidence or hear proceedings. But just to tease up these two issues, the two issues broadly factor out into public access to justice and access to justice, public access to the proceedings and access to justice itself. I'll deal with the latter because it's quickly disappearing, but it was one of the first objections that came out when the approach to this system was evolving. And it's based loosely on Section 36(1) of the Constitution, where it says in the determination, and we're all familiar with it, in the determination of civil rights and obligations, the issue of fair hearing by a court or other tribunal constituted to secure independence and impartiality, and the whole concept of the court being a place. I think that the comments I've made earlier on would deal with the fact that a court is not a place. It is where the authority of the court is assembled. The majesty of the judex and his judicial powers are properly put into place, and justice is dispensed therefrom. But I think the more problematic one would be Section 36(3), which relates to the public access, which I think my Lord, Mr. Justice Oshodi mentioned earlier on, and which clearly occupies the space in the area of possible and rather formidable objection. Formidable, but not indispensable, because I think it's easy to dispense with, and we need to be able to make sure that as a body, we're thinking of ways to deal with these objections. And 36(3) has been pointed out, deals with, and we're familiar with it, proceedings in a court or any tribunal relating to matters mentioned, and the decisions of the court or tribunal shall be held in public. And there goes that word. Now, I think as far back as 1973, in the Oviasu decision, which was cited in the case that my Lord Oshodi relied on, and I'm going to refer to that in more detail. As far back in 1973, in the Oviasu decision, it was clear that judges' chambers is not a regular courtroom, all right? And then this is where the argument has dovetailed on that, well, there is this analogy between a judge's chambers not being a public place or accessible to the public. And then therefore the analogy that if I'm online, it is not a place that is accessible to the public. And therefore it doesn't satisfy Section 36, Section 36(3), because the word public is not met by an online hearing. And the Supreme Court had held that even if there's no right of ingress and egress as of right, as long as that right can be conferred on the public, the issue of the place can be satisfied, even if it is a judge's chambers. And then that was also treated in Mohammed and Wobudu, where the Supreme Court again says, well, acts of secrecy, wherever they are found, will always offend the independence and impartiality perception of the courts. But I don't think the problem came from there alone. In fact, everybody would have been easily forgiven to have thought that Oyetibo and Oyinoye in 1987, with a distinguished panel led by Justice Obaseki had dealt with the matter entirely. So the analogy of this online hearing being somewhat analogous to decisions of judges or proceedings within the chambers that is being touted today was considered only in the context of hearings in chambers in Oyetibo. And the court was very clear. And I think it's important that I read part of this. When the court sits in chambers, all it means is that the judges of the court are transacting the business of the court in chambers instead of open court. And it cites an English decision. It does not mean that the court is not sitting in public. A court can sit in open court and yet decide and exclude members of the public other than parties and their legal representatives from the hearing in exercise of its statutory powers. And so it wasn't the fact that you weren't in court, but the fact that you had access to court that would allow a judge's chambers to satisfy the meaning of the Constitution, the wording of the Constitution and the word public. And clearly the argument would suffice for the hearings online, because the argument being touted that, well, I don't have access to the hearing. Now, access is often provided is always provided in a properly constituted virtual hearing, because invitations and links are sent to the public. As my Lord, the Chief Judge said earlier on, not all courts can sit 300 people. And I note in this webinar alone, there are about 500 people listening. So if this was a courtroom and this was court proceedings, you'd have 500 people. So it isn't as of right means that you have access, albeit you are not actually physically there. But then the disturbing matter came with the decision that my Lord Justice Oshodi mentioned, Ikoshebinu and others versus Alimi. So after 1987, that we all thought, well, you know, this issue won't come again. It rose again in 2005, where the Supreme Court agreed with, in 2016, where the Supreme Court agreed with the Court of Appeal in 2005, and essentially said that a court must be, neither the parties nor their counsel, and indeed the public at large, would have access as of right to judges' chambers. So if you place that decision within the context of the objections about public and objections that online proceedings are no longer public, and because Koshebinu and others states that a Supreme Court decision as recently as 2016 seems to be preferred to Oyetibo, where it was felt that, you know, a court can be in chambers and deliver proceedings and satisfy the Constitution. Now, my answer to the fact that, well, the current state of the law is that the dicta in Koshebinu is one that you must have a hearing in the courtroom to satisfy the word public, is that cannot be the correct position, because Oyetibo dealt with a range of issues, whereas in this peculiar facts of the Koshebinu decision, the 2016 decision, the court was faced with the fact of a judgment being delivered in chambers. And it wasn't a matter of the proceedings. So one of the ways out of these inevitable objections that will arise will be that hearings, virtual and remote, can be conducted online, but judges should be careful that perhaps in the delivery of the judgment itself, a court is convened in a physical place, even though I don't think Oyetibo contemplates that case, and it's distinguishable on the peculiar facts. But to arm the judiciary and to arm right-thinking counsel about how to deal with this objection, I think perhaps until something arises, it would be probably prudent to avoid the delivery of judgment in an online proceedings. That could be the way out. But having said that, one must always bear in mind that neither of these decisions, indeed all of these decisions, could not have had practice directions or civil procedure rules as are in the offing under the current situation where the COVID-19 situation has brought about these rather emergency provisions. So the courts could not have been interpreting the state of the law at that time, including rules that didn't exist at the time, and even which would include 2016. And you know, you can be sure that our colleagues would raise these arguments, but the state of the law, as in Koshibinu, deals with only a judgment of the court in that particular case, whereas the dicta in Oyetibo was a lot more expansive than that and deals with several situations. Before I yield, I think it'll be good for me to point out certain developments abroad that can be of assistance in the thinking behind dealing with this situation. It was brought to my attention by a colleague only just this morning that a decision in April 2020, which is last month, Mr. Justice QC, in a case called Municipal, I can give the citations to the organizers, brought out certain guidelines. And the interesting thing about that is that the guidelines somehow echo the commencement of the protocol that I've seen that the Lagos State Judiciary has released and that we're all considering today. In the early part of the protocol, the practice directions, it states that there are two situations that will be considered. Even though if it doesn't state it in this way that I'm paraphrasing, it says new cases where there is urgency, pending cases involving urgent or important and time-bound interlocutory applications, bail, etc., and any other matter as the chief judge may approve. So it deals with two types of situations where the hearing as of necessity must be conducted because there is an urgency relating to the matter, and a situation where a judge, either delegated from the chief judge or the chief judge himself, says that it is a situation where these proceedings must be held remotely and virtually. And that way you will deal with objections like, as Mrs. Essien will probably treat, cooperation and mandatory cooperation or mandatory participation. Just to run through Justice Ayer's guides, and again I'm paraphrasing, he says, one, when the delay results from a response to this prevailing circumstance, the continuation of justice is deemed to be necessary. Two, the disputes can in fact be resolved fairly by a remote hearing. Three, the courts are prepared to hold such a remote hearing. That means the judges themselves have decided that it will be done. Four, under rigorous examination, the possibility of a remote hearing is there. And five, a remote hearing must be treated on a case-specific and dispute-specific basis. So previous speakers on issues of evidence can actually find the proceedings truncated into different parts, where certain parts lend themselves to virtual proceedings and certain parts do not. And in my opinion, as I close, is to say that whatever we do in support of this reform, we must bear in mind that it is designed to ensure that safety is not prejudiced, and at the same time, the risk of injustice is not prejudiced. And if those two factors are satisfied, I think we cannot have a situation where we are all looked upon as a community as being inadequate to deal with, as collectively inadequate to deal with this pandemic and still deliver a system of justice that serves all the stakeholders in Nigeria. And I'll yield to Mrs. Essien on that point.
Thank you very much, Mr. Shasore. I think you ended up on a very interesting note, which is the balance that COVID-19 has forced upon us to try to strike, maintaining health and safety, and on the other hand, ensuring the justice system continues. And that's really what this is all about. Mrs. Essien, I give you the floor.
Thank you. Thank you, Tunde. My Lord, the Chief Judge, my Lord Justice Oshodi, the Honorable AG, the conveners, panelists, my dear panelists, thank you all so much. The lovely thing with speaking at a time like this is by the time it gets to you, everybody has covered the field. So typically, If this were a court of appeal, I could have just said I concur, and then I would still get my honorarium if Tunde was giving us honorarium. But I'll still address some of these issues before my Lord imposes costs on me as he has on Taiwo. So why are we having this conversation? COVID-19. In January 2020, if anybody told us we'll be sitting down here looking at our laptops and having a webinar, we would have said it's impossible. But that's the reality. Things change so suddenly, and we have to adapt to the times we find ourselves. For the same reason, are virtual hearings constitutional? Shukboza addressed everything I would have said, so I won't dwell on that at this point. But just to point out that, as has been said in Rabiu and State, the Constitution is dynamic, and you interpret it as you go. And so I have no doubt that if this were to get to the Supreme Court, the meaning of public would be interpreted in a way that would definitely cover the situation we find ourselves in right now. Because at the end of the day, what are we dealing with? We're dealing with a person's right to fair hearing. And part of that fair hearing suggests that your case must be heard within a reasonable time. For it to be heard within a reasonable time, there has to be access. And if there's anything that's stopping that access, that's where the judiciary comes in. And that's why, my Lord, the CJ and other judges, chief judges of other courts have started coming out with their practice directions. Primarily, the focus has been on urgent, essential matters. But then what happens to regular cases? And our analysis tends to focus on the cases that are on the face of those cases urgent and essential. So a bail application is urgent. Fundamental rights is urgent. But that's on the face of it. But I could have a debt recovery case, and the money is important to me, but it's not apparent on the face of it. That is urgent. So I need to be treated in a similar fashion. So how do we do that? And that's part of the conversation we're having right now. So, do the virtual hearings cover the issues of the practical considerations? Yes. And virtually every speaker, my Lord, the CJ, Justice Oshodi, I beg your pardon, we've all touched on that. So I won't go into it. But then how do we ensure that it appears so? I think some practical steps. Publishing it on the website, the cause list on a weekly basis, setting out clearly the matters that are stated for virtual hearing so that everybody knows those ones are going to be heard virtually. What are the practical issues we're going to have to deal with? There is definitely going to be a lot of pushback. And if we read the chats, we can see some analysis. For instance, the issue of demeanor of witnesses. But then ultimately, when judges decide cases, they don't decide it based on the demeanor of witnesses. Cases are decided based on the evidence. And so my lords here are familiar with witnesses who will look you in the face and lie through their teeth while looking very, very innocent. So ultimately, I think that there's going to be less focus on how the witness looks, and it's going to be the evidence that supports whatever the witness says. And so in making the justice accessible to everybody, how do we do it? We do know that there are going to be technical challenges, and we've had some already in the course of it. Sometimes it goes off, the connections are not too good. So there's definitely going to be the need to train paralegal support, technical support, both in the judiciary and even amongst practitioners. So we need to have competent support staff. Another point which is essential is that not every case would lend itself to remote hearing or virtual hearing. And I think that point has already been made. Some are more readily disposed to that. Originating summons, fundamental rights, those upon which affidavit evidence, the cases based on affidavit evidence. But family court hearings, matters that are sensitive, things like that, you may need physical hearings. And the reason why it's important for us to remember the distinction is that we're trying to deal with the COVID-19 pandemic situation. So in as much as virtual hearing is appropriate for what we are doing right now, we all pray that, say, in the next 1 year, we'll all be getting ready to go back to court. So we're trying to make provision for the situation we find ourselves in. Will it dovetail into impacting the way we conduct cases on a day-to-day basis? Definitely it will. But I think that when we are having this discussion, I think it's to bear in mind that there will be the possibility of having a physical hearing as well as choosing to have a virtual hearing, depending on the circumstances. And ultimately, it is possible that the chief judges, the heads of court, will make appropriate practice directions or amend the rules so that people may have that choice should they desire. So, but at the same time, talking about pushback for various reasons, even when we started, when we were filing witness depositions, people pushed back written addresses. So it always takes time to introduce new things, and with time, it'll catch on. So what do we then do when a party is uncooperative? The rules would have to take care of that. Now, right now, parties do have to consent. So you'll have to do an analysis as to a case that needs to be heard virtually as against one that is convenient. And so if it needs to be heard virtually, then the state may have to make provision for facilities for those that can't afford the facilities or don't have the facilities. Because whether we like it or not, perhaps you're in Lagos and the internet, you have 5G, you have 6G. Some people in other places may not even have 2G. And that's just going to affect their ability to participate in the remote hearings. And so I think that's the key thing for the court to then decide to make it compulsory in certain instances. And where that is the case, give the parties adequate time for them to set up whatever facilities they need to put up to suit the appropriate purpose. And so using my lords, the chief judges, or the chief judge of Lagos State's practice directions, we can see from that one that the parties are actually to agree as to whether they want to have the online hearing, which of course is a good thing, considering the fact that this is new and it's going to take some time for everybody to become acclimatized and used to the procedure. And so the parties right now have to indicate their willingness. In Ogun State as well, there's supposed to be voluntary participation. So I think with that and what everybody else has been said, and with Tunde's timing, I think basically I've come to the end of the practical considerations. And just to say that we all have to move with the times. I did a presentation a couple of weeks back, and I did say then that law practice will be considered in terms of BC and AC, before COVID and after COVID. And I think that's exactly where we are right now. Thank you, Tunde, and I'll
Thank you very much, Mia. Thanks so much. You just underscored what will appear to be a marked difference in the approaches. So Justice Eyre's decision, which Mr. Shasore quoted now, actually starts from the proposition that the person who does not want a virtual hearing has to prove why there shouldn't be a virtual hearing, because the other person also has a right to have his or her case decided expeditiously. In Nigeria, where we seem to be at present is that parties have to consent for there to be a virtual hearing. And that may well be because we have legal provisions that we have to overcome to be able to achieve that through rules reform, through more practice directions. That's a point that I would leave to my Lord, Honorable CJ, to address in his closing comments at the end of this session. I have one other question from him, from one of my Lord's learned brothers, which I will also pose. For now, I will hand over to Mr. Bola Adeniro, the Honorable AG of Ogun State, who, like I said, has joined us on invitation because Ogun State ran its virtual hearing process, did a trial run yesterday, and there are some experiences that he will be able to share with us for our benefit. So Mr. Adinero, I hand the floor to you. Thank you very much. You're welcome.
Thank you very much, and thanks for the invitation. Again, it's a privilege to participate in this workshop where we can talk about continuing with our justice system. And I think in Ogun State, we understand the issues in two ways. And I think both ways were covered by Mr. Shasore, Leonard Silk, and Mrs. Essien, Leonard Silk as well. And one is basically continuing with justice, a continuation of justice. We need to get our courts back in operation because you can't put justice on hold. And then the second aspect, of course, is trying to see how we can be more effective, more efficient in justice delivery going forward, and how we can deploy technology, whether it's through virtual hearing and so on, to make justice delivery more effective. In Ogun State, when we piloted virtual hearing, I would like to say it was a hearing with an online component or a virtual component. Because the learned chief judge sat in open courtroom, and the defendant, who was in Ibarra prison custodial center, connected via video conference. The counsel, defense counsel, and prosecution were in court, and so the only person who, of course, members of the public also connected remotely, but the only party who was not present in court was the defendant. And so we had to look into ways of getting the connection from the custodial center to the court to be good enough for a virtual hearing. And there are challenges that I take the point that one of the speakers mentioned earlier when it comes to internet connectivity. We were surprised that even in Ogun State, in Abeokuta here at the Ibarra Custodial Center, the quality, the bandwidth of the internet was not good enough for a Zoom video conference. And so when we tested the internet speed, it was 2.6 Mbps. And to have a good uninterrupted video conference, you need at least 5 Mbps. Luckily, we had an alternative that we had worked on, and we did a point-to-point radio connection, which essentially used fiber optics. And so with that connection, we were able to get uninterrupted internet connectivity with Ibarra Custodial Center. But you can imagine that that's because we had the infrastructure in place. There are many places where that infrastructure is just not present. And so when you think about connectivity issues, it's still a thing we need to discuss more broadly. Power was also an issue. At the custodial center, power is not constant. So we had a backup generator, which of course we fueled in preparation for the session. And this is something that people sometimes do not bear in mind, because if you don't have all your emergency backup systems operating, you will have an interrupted session. Troubleshooting support, having technical people on hand who can advise, who can solve problems as they go along. We had a very short period within which to train the court registrars. And so we were able to get the permission of my Lord, the Chief Judge, for one technical person to sit with the court registrars, at least for that session that I held yesterday, so as to hold their hands and guide them through the process. But of course, subsequently, we will organize a training for the judicial staff, as many of them as possible, so that everyone can be on board as to what needs to be done. We would like, of course, the Nigerian Bar Association to also lead from the front. This is an issue that I think affects lawyers. It affects lawyers both working in the public sector and lawyers in the private sector. And unless we have a concerted effort from everyone, the judiciary, it looks as if it's the judiciary that has been leading the effort. Of course, that's not to say that people like Mr. Tunefa Gondu and so on have also not been doing a lot. But in terms of the NBA, my opinion right now is that the NBA is not as proactive as I think it should be. I think when we talk about how the proceedings can take place, and I take the point from Mrs. Essien Leonard Silk, that if we have a balance between virtual and physical, because we are not saying that physical can no longer hold. And I think always having that in mind, that there's always an alternative as long as we respect the NCDC prescription as to how to operate in a safe manner. And so understanding that we can still have physical hearings with online or remote aspects combined with different, so we can have physical, purely physical, we can have purely online, we can have a mixture of the two. And having this as a system to go ahead, a system to pursue, we know that technology in itself is not the solution to everything, but technology can help to assuage some of the problems that we would normally encounter. And of course, this is not to also remove the fact that the attitude of lawyers plays a significant role. And I've been very impressed with today's workshop, because even though we've identified problems, we've looked for solutions to those problems. I've been on many fora, many platforms where we only identify problems and leave it at the problem stage without talking about solutions. And I think we should lead from the front by discussing solutions, because the alternative to all this is that justice just stops. And that's an untenable alternative. And this, for the people who are trying to find solutions to make sure that the wheels of justice continue, I think they should be encouraged and they should be supported with good ideas, with constructive criticism, so that things can move forward. The experience yesterday, there were the financial aspects to it, because we had to equip the Barra Custodial Center with video conference facility. And of course, this is a federal facility and it's a state government that is equipping them. But we thought that that's something that is important in order not to stall criminal cases, because the defendants also have a right to be heard and they have a right for their matters to continue. And I'm sure everyone is aware of the directive from the federal government preventing any inmate from being taken out of custodial centers to court for fear of catching the coronavirus. And so there are some matters that we have to basically think about, that there's no other alternative but to use virtual components or virtual hearings so that they can continue, and others where it's convenient, it makes things faster, but it's also the possibility that we can also do the same in a physical courtroom. And so that said, I didn't really come in with a prepared speech. I just wanted to share my experience and the experience of Ogun State and in piloting our own virtual hearing yesterday. We intend to expand to all courts in the state, both the High Court and Magistrate Courts. It's a huge exercise. We have to train a lot of people. We have to get a lot of people involved. The Honorable Chief Judge is very much at the forefront. She's leading all efforts in this regard. And she's someone who is proactive. And I think that's very essential if this is ever to go ahead. And I also know that the Honorable Chief Judge of Lagos, with whom I've spoken in the past, is also very passionate about these issues. And so I thank you again for the invitation, and I look forward to the questions.
Thank you, Honorable Attorney General Ogun State. I don't think any prepared speech would have done the job better than what you've done just now. And I think the key for me there, the point you made about justice must continue. And I guess it's up to all of us not to see this as a binary problem. It can either happen or it cannot happen. In between, it cannot happen and it can happen. There are so many intermediate solutions that we can all explore to make sure that justice continues to progress. Thank you very much again. If there are any questions for you, I'll bring them to you before the end of this session. We're running very much out of time. I will now go through some of the questions that we have got. I'm afraid I'll probably only be able to take 3 of them because time is running out, like I said. What we plan to do is to curate all these questions that we've got. On the Q&A panel right now at the top right-hand corner of my screen, I can see 44 questions pending. We will not be able to take all of them today, I'm afraid, and with all apologies. But we'll curate all of them into a discussion document, which we will circulate to all participants, and more importantly, to my Lord, the Honorable CJ of Lagos State, and all other heads of courts, because this workshop has generated quite a number of issues that policymakers must take into consideration, that our heads of court must take into consideration as they begin to prepare perhaps more elaborate practice directions to open up the courts a bit more beyond just what we currently describe as urgent, time-bound, and essential cases. So the first question that's come from one of our participants, I think is relevant to our constitutional panel, and that is Mr. Shasore Essien and Mrs. Miannaya Essien. And the question goes as follows. Can an applicant for bail, for instance, opt for open court hearing, probably for the reason that he does not have confidence in the ability of the correctional center to be able to link up virtually, or because he would not be able to confer with his counsel? That's a question from Dotun Onibokun, Honorable Justice Dotun Onibokun. Our constitutional panel, Mrs. Essien, Mr. Shasore, would you like to deal with that?
Well, I'd be surprised if any person awaiting trial or awaiting the hearing of his bail application is not desperate to get the matter moving forward. So a question of confidence is natural, but the same issues of confidence could always arise even without the virtual hearing. I mean, would he be transported? Would the warders be there? Would there be electricity in the court premises? There are quite always variables in these sort of things. So, I mean, the short answer to it is that, yes, he could insist on a mixture of both the virtual hearing as well as a physical hearing in order to ensure that his confidence is put to rest. The appearance of a reasonable and fair trial is very important as to the public as well as it is to the defendant himself. So I think the short answer is yes, he could opt for that.
Yes, and I agree totally with Shukbo, and I don't have anything further to add. Tunde, you're on mute.
Thank you very much, Mia. Thanks for drawing my attention to that again. Very well. The next question I will pose to our evidence panel, and that is, it goes as follows. The Cybercrimes Prohibition and Prevention Act of 2015 provides a list of transactions and declarations that shall not be valid by virtue of electronic signature. That list includes issuance of court orders, notices, official court documents, such as affidavits, pleadings, motions, and related judicial documents and instruments. Does this provision not affect the ability of courts and parties to issue and authenticate documents electronically? Now, my view, I mean, not to preempt the speakers on the evidence panel, but my view, of course, is that this doesn't in any way criticize the process of virtual hearings. It only says, how do you authenticate documents? And my thinking is that if you sign a document in a regular form and scan it and upload it, that does not detract from the fact that it's a valid document, notwithstanding the reference provision of the Cybercrimes Prohibition and Prevention Act of 2015. But I will give the floor to you, Professor Osipitan and Mrs. Agbor, for your views on this subject.
Sorry, today, could you add the issue of subpoena witnesses so that I can take it at the same time?
Very, very well indeed. There was a question on subpoena witnesses, and it says as follows: how will subpoenaed documents be attended to? Will there be subpoena hearing at case management conference for submission of documents? Is that the one you had in mind, Mr. Oyetibo?
No, subpoenaed witnesses. If a subpoenaed witness refuses to cooperate in a virtual hearing, how do you deal with it? He has been served with a subpoena. The normal thing is that he should participate. If he refuses to go to the office of the council at whose instance the subpoena was issued, he decides to stay in his office and he says, I don't have data to join your virtual hearing. How do you deal with it?
Very well. So thanks very much for articulating the question, Mr. Oyetibo. So I'll give the floor to Professor Osipitan, Mrs. Agbor, and Mr. Oyetibo, if you wanted to put in any points in addition to what they say, please feel free to do so.
Okay, thanks. Yeah.
Prof.
Let me take Mr. Oyetibo's question, which is the last question. Sure. In terms of subpoena, when a witness is subpoenaed, it's an order from the court that you must appear at a particular place and time to tender documents or to give evidence. So if for any reason he is not able to attend, the court must know in advance. And if he just sits down in his office and says, I cannot go, I cannot waste my data, then what he does amounts to contempt of court. So I would think that the best thing to do for a witness in the circumstance is to insist that as a witness, the cost of either attending or making sure that the evidence is produced be paid by the party that is asking him to come. It's like you asking the witness to come and testify without tendering the expenses or costs of such a witness. But it will be out of place for anybody who is subpoenaed by the order of the court to refuse to come and say because he has no data. If he has any problem, he should let the court know. Such a witness, I believe, stands a risk of being convicted for contempt of court. Now,
indeed. Yeah. Yes, please.
Yes, now to the other question, which is that the provisions of the Cybercrime Act. We'll have to look at that provision very well and see whether that provision applies to all situations, or it applies only to cases that deals with cybercrime. Each legislation has a purpose and it deals with specific issues. It could very well be that when you are looking at whether somebody is going to be convicted for cybercrime or has done ABC and is standing trial under the Cybercrime Act, then that provision will apply. But I doubt if that provision will apply in all situations. Particularly, you take a bill of lading, some are signed electronically. There are banking transactions that are being done on a daily basis electronically. If you say that Cybercrime Act has universal application, that means that all those documents we are signing, all these e-contracts and all documents from countries abroad would also be seen to be violating the Cybercrime Act. I do not think so. And again, to also lend credence to what Tunde is saying, that sometimes when something is signed and a document is signed and is sent electronically, maybe it's you send it by email, scan and send, that does not violate the provision of the Cybercrime Act. At best, what you are doing is you are reproducing the document already reproduced, and it will be admissible as secondary evidence if you lay proper foundation. But like I said, I do not think that that provision is of universal application. I want to believe that we should restrict its application to instances where somebody is being tried under the particular provision of the Cybercrime Act. Thank you.
Thank you very much, Prof. Mrs. Agbor. I don't know if Mrs. Agbor.
I think she went off.
Yes,
no,
yes.
I was trying to unmute. Each time I unmute, I keep picking up the video or something. You all have to get very, very, very adept.
Training, right?
I'm telling you. So I agree absolutely with what Tunde's first initial comments and to what Professor Osipitan has just said. In terms of the subpoena, as I said before, a court, whether it's in person, physical, virtual, is a court. It is constituted by a judge. So any order that the judge gives is an order of the judge, is an order of the court. So a subpoena is an order of the court asking somebody, requesting or demanding or ordering someone to come and give evidence, whether a testificandum or what's the other one, docu something.
Yeah.
Secum and a testificandum. All right, so we are still in that age-old time. So obviously, if he fails to comply with the court order, he's liable to contempt. So I think Professor Osipitan has mentioned that, so there's no point repeating that. On the cybercrime issue, I also agree with both what Professor Osipitan and Tunde have said. I think it goes to the admissibility of documents eventually, and we've already had that discussion. It could be once the document has been properly signed and parties agree, maybe at a pre-trial conference of counsel, agree the documents, then those documents go in as evidence. I don't see how, if it's properly authenticated, that parties will not agree that should form part of the bundle of documents that will form part of the evidence that's going to be form part of the bundle of documents that will be used by the courts and by the parties and by the witnesses for the trial. So I don't really see any thoughts there.
Thank you very much, Mrs. Agbor. And then
Today, sorry, can I just keep this in just to support what Prof. Funke had said. I believe even in virtual hearing, the judgment of the court will still have to be signed by the judge manually before it is circulated. And even the witness statements will still have to be signed manually. So that is not electronic signature anyway. You sign manually, then you can then scan and send. That will not be considered to be electronic signature. So I think the rules will still be met, and the provision that the gentleman has alluded to wouldn't have been violated in any event.
Very well. Thank you very much, my president, Mr. Oyetibo.
Tunde, can I raise that issue?
Yes, please.
There is an issue regarding oath take, which Mrs. Agbor addressed. He addressed the issue of taking the witness who is about to give evidence, taking his oath, but she didn't address the issue of, so with this remote hearings that we want to do, so what happens to affidavit evidence? I think the question was that, so does the witness still have to go physically to the court premises to depose to affidavit evidence before the commissioner for oaths? Or is there a method by which this can also be done remotely? I think that was what the question wanted to address. So if she can address it now, it would be very nice. Thank you.
Thank you very much, Attorney General.
Yeah. As regards affidavit evidence, that, I guess, that does not really have anything to do with remote hearing or virtual hearing. Is as to a document that will be signed or is required to be deposed to an oath. I guess that would be part of maybe e-filing. I'm not quite sure, because it will be part of e-filing. So just as you submit a document for into evidence, whether it's primary evidence, whether it's secondary evidence, it's an affidavit, is part of the evidence that you are producing, properly signed and deposed to. So I don't know that you can avoid a physical deposition of the document in the courtroom. I'm not quite sure whether that is possible. I don't know that we can avoid that entirely, except there's an e-process, an e-filing process of that. But the document itself needs to be signed, needs to be properly deposed to. And unless it's agreed that you can have some kind of stamp or seal without it, or you have an automatic seal, if you have an because usually, well, in e-filing of cases in other courts, in other jurisdictions, once you file, it automatically generates a document that shows that it has been sealed. But with an affidavit, I really think it looks as if, to me, from where I sit here, that you may need to be physically signed before a registrar or maybe a notary public.
Yes, I think that maybe the rules should begin to permit litigants to resort to notary publics, so that if the affidavit is notarized before a notary public, it can then be attached to the court processes that will be uploaded. I don't know if my Lord the CJ, I can see maybe he wants to say something on this too.
Yes, of course. Thank you, eminent panelists. Like I said earlier, yesterday while we were discussing all these scenarios at our meeting, the issue of swearing to affidavits came up. And what we proposed, which we are likely to set about doing with the appropriate facilities in place, is to have a dedicated commissioner for oaths who sits in a place in our registry here, and the person who wishes to swear transmits the document to the commissioner for oaths here before swearing, and then he takes his oath there, because the relevant words of the law which commands the presence of the person swearing before the commissioner for oaths, before me. So if he can stand there and then take his oath there, which the commissioner at the other end here is listening to and watching, and signs in his presence there, which is also seen, then I think it will satisfy the provisions of the law. There might not be necessity of him coming to court first. He's been able to file E. Now, we have that facility there. It stays somewhere, haven't been allotted his time to come up for the swearing. Now, he swears to the document, he signs in the presence of the commissioner for oath, and in turn, the commissioner for oath also appends his signature at his own end as to attestation. I think the process is completed. That's what we are proposing to do. We are looking into it. But if you can have some other additional suggestions on that modality, you are welcome. So
sorry, my Lord.
Yes, please.
Yes, my Lord. Would that be
support.
counterpart signing?
No. It will have transmitted the documents electronically to the court. He has filed already. Now he's just taking his oath there. He's signing in the presence of the commissioner for oaths, who is also watching him on the screen. And as soon as he signs, he gets back to the commissioner for oaths here, who also appends his own signature for attestation. And then a certified true copy can always be obtained from this end. That is what we are thinking with.
Yeah. That seems
perfect. I just
perfect.
want to chip in, please. Today, sorry. I just want to chip in on the issue of a witness who is refusing to attend court. I think I support the speakers. It is plain contempt of court. The words of the subpoena, whether duces tecum, as Funke was trying to get, or ad testificandum, or both. The word there is, you are hereby commanded in the name of the governor of Lagos State. Command might seem on democratic language, but then that is what we still have on the summonses. And so it's a command. You cannot use any flimsy excuse. I haven't received the process to say, well, I don't have power, I don't have data, and then you just won't attend the proceedings. No, such a person will be liable to contempt. But again, you practitioners are the one who will be at the receiving end. This is because if the man is forced and he now comes over to come and testify, I hope you won't need to declare me a hostile witness. Because so you forced me to come, all right? Taiwo, you know what you went through at the tribunals.
I know, my lord.
So we have we had a discussion.
Yeah. My lord, CJ, with due respect, there's one application left. The application against Tunde for costs. We're still waiting for the order.
Sorry, so at this point, let me thank you.
In the spirit of this pandemic period, I waive costs.
Thank you very much, my lord. We are going to be logged out in about 30 seconds because we had 3 hours. We actually were thinking we'd finish in 2 hours, but we've done 3 hours, just a few seconds.
Well, sorry, that's one of the things we also considered here. At our end, when my brother Judge Dadaje was reading the judgment, I think we booked for 2 hours. But proactively, we thought, all right, this judgment might go beyond that. So we now increase it to a booking for 3 hours. I think that's one thing we may need to do. And finally, let me just chip in that you lawyers have a lot to do in this enterprise that we are trying to embark on, particularly the senior lawyers and affluent ones like Tunde and all the rest of them. You need to help your juniors to get facilities to be able to latch on to this methodology of hearing. Please, at the bar level. Yesterday, I was speaking here with Dele Oloke when he came shortly after our meeting here. And I told him, look, the branches can buy these laptops for junior ones, ask them to pay installmentally over time so that they will get started from the word go. And once counsel in their substantial number are able to latch on to this, then we have to think of also the citizens. So that if a citizen cannot have a compliant phone or gadget to partake in this kind of a hearing, then the lawyer can call him to his chambers and both of them can be together. At least you'll be able to latch on to the facility of the lawyer and then the proceedings can go on. I think we all have to put all hands on deck in respect of this project. Thank you very much. I thank all of you very much.
Thanks so much, my lord, for those words of conclusion. The Honorable Attorney General of Lagos State, I don't know if you have any final words for this conference before we bring it to a close.
Well, I nothing to add other than to thank everybody for taking out time to make this the success that it has been, and that as we go forward, we definitely need to engage further, learning from all issues that are there, making the process better, making it that it would very much for making out time to be with us today. Both the panelists and all the over 500 participants watching this. Thank you all very much.
Thank you very much, Honorable AG. I want to thank my lord, the Honorable CJ, Lagos State, all my lords, my ladies, your worships who have observed these proceedings, learned senior advocates of Nigeria, ladies and gentlemen of the bar, both from practice as well as in-house counsel who have joined this event. Our friends from abroad, Daniel and Joe, thank you very much for coming to share your experiences with us. We have gathered a lot of useful information in this session. We are going to curate, like I said earlier, we're going to put everything together. We'll build a discussion document out of it, and we'll share it with all the heads of courts and all policymakers who are responsible for ensuring that we have an effective, efficient, and just administration of justice system going forward in these very uncertain times of the COVID-19 pandemic. And indeed, beyond the pandemic, the experiences that we have now, the new techniques and the new knowledge we've gathered will help us even make the justice system better going forward. I want to thank everyone. I now bring this session to a close. I wish you all a very good day and a very good weekend coming up ahead. And please stay safe, everyone. And we'll come back to you with more series and more policy documents. Justice Reform Project, CRID-LawNet, the Ministry of Justice say thank you to everyone. Thank you very much.
Thank you.
Thank you very much.
Bye-bye.
Thank you.
Thank
Bye.
you. Bye.
Thank you. Thank you.
Thank you very much.
Thank you.
Thank you. Thank you.
Taiwo.
Thank you very much.
Yes, my lord, have a good day.
Thank you very well. God bless you.
Thank you, my Lord. Yeah, thank
you.
you.
All of you there. God bless you all. Thank you very well, very much. Have a nice day.
Thank you.
Taiwo, Toki.
Alafia, my Lord.
Alafia.
Osa.
Thank you. Bye bye.
Okay, my Lord.
Right.
Bye all.
Quite interesting. And you slept off. You ask you what you discussed. You are slept off.